Second on one part. Oh, that was like walking the bill.
Oh.
All right, we can get started now. I just tried to call. Hi, ladies and gentlemen. Welcome to the July 2021 meeting of the Tennessee Real Estate Commission. We're happy you're here and look forward to an efficient, well-organized meeting. That part might be a little tricky. With that said, Ms. Maxwell, Executive Director of the Tennessee Real Estate Commission, will read a public disclaimer into the record, and then for the record, she'll call the roll. Caitlin?
Okay, notice of the July 7th meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since August 26, 2020. Additionally, this month's agenda has been posted on the website since July 2nd, 2021. For the roll, Commissioner Joe Begley,
Here.
Commissioner Jeff Diaz,
Here.
Commissioner DJ Ferris,
Here.
Vice President Marcia Franks,
Here.
Commissioner Steve Gwynn,
Here.
Commissioner John Moffitt, Commissioner Joan Smith, Commissioner Stacy Torbett, Chairman John Grease. You have a quorum.
Thank you. And it's good to know that Ms. Franks is now Vice President.
You know what? She's always vice president, but sometimes for my own ease of keeping everybody straight, she's also a commissioner.
Well, not only that, she is president, right? President of the Association of Real Estate Licensed Law Officials,
Yes.
current an international organization, and one of the high honors ever bestowed upon a woman or a man of any type in the state of Tennessee. And with all that said, I want to ask President Marcia Franks to lead us in the invocation, and then if you'll stand following the invocation, she'll also lead us in the pledge to the flag. Marcia.
Bow our heads, please. Thank you, God, for this beautiful day that you've given us in the great state of Tennessee. Thank you for all of our blessings. Thank you for our Independence Day, Lord, and help us to be mindful of the sacrifices made for us by others. Be with our military today and every day, Lord, as they fight on our behalf. We ask you, Lord, to bless our state workers today, our governor and our president. Please help us today as we make judgments upon others, that we would be filled with grace and discernment. And thank you, Lord, for the peace that you give us. In Jesus' name, amen.
Amen.
Let's stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Marcia. And we'll look forward to getting a report from you and others who've recently attended the Arello conference. All right, next up is for this commission to approve its agenda or to modify it if you so wish. Commissioners, Marcia.
I'd like to add, I didn't see anywhere on here an Arello discussion, and I would love for to maybe put it under the commission discussion, and for those who attended to speak about Arello also.
Let's make it the first bullet. You want
Okay.
to do under commission discussion.
Motion to approve as amended.
Second by Mr. Bagley. So the motion on the floor is to approve the agenda as amended. That motion was made by Mr. Diaz and seconded by Mr. Bagley. If you have any comments before we vote, please let me know. If not, if you're in favor of the motion, please vote aye. If you're
Aye.
opposed, vote no. And that motion passes unanimously. Next up is to approve last month's minutes. Is there a motion?
So moved.
I have a motion by Mr. Diaz, second by Ms. Smith, that the minutes as presented to us electronically be approved. Any corrections, additions, discussion? Since there is not, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes.
Chairman, I
unanimously.
abstain. I was missing last month.
So we have 6 ayes and 1 abstention. Ms. Franks abstains. But you were watching,
I was watching, but I wasn't here.
so you don't want to go out on a limb and
No.
just checking. You seem kind of far away to me, Marsha, right now. All right, next up is an informal appearance by somebody named Candidate A,
Shelley Copeland.
Shelley Copeland. Is she behind us on the screen?
Yes, she is. And I thought she might be over there as well. But yes, she's in the top right corner if you turn around.
I would say, Commissioners, probably if you'd like, there are other seats over here on the side where you can see without twisting your neck in half, which is where I'm going.
I'll give the commission an update. Before you, you have applicant Shelley Copeland and her principal broker, Victoria Carmack. Ms. Copeland, as of the writing of this, had not taken the real estate affiliate broker's exam yet. Her principal broker, Victoria Carmack, was first licensed in 2004 and then licensed as a broker in 2018. The firm is One Source Realty, Pros LLC, and a summary of the criminal and disciplinary sanction is a theft/drug charge. Ms. Copeland's statement and letters of recommendation can be found on your iPad.
Thank you. So just so I can be clear, Ms. Copeland, would you put your hand in the air just for a second? Okay, so you're the applicant. Okay, perfect. In this procedure that we follow, Ms. Carmack and Ms. Copeland, we're going to ask Ms. Copeland to give us the story about why she's here in front of us. Any information you would like to share with the commission that you think could help your case. When you're done and you have as much time as you want, commissioners will ask you questions if they feel there are questions they need to ask. Following that session, we'll go to Ms. Carmack. And Ms. Carmack will ask you to give us some reasoning why you'd like to have Ms. Copeland associated with your firm. Following that, I expect we'll have a motion either to grant your request or to deny your request. We'll take a vote and we'll see how it goes. Any questions before we get started?
No, sir.
Okay, so Ms. Copeland, what got you in front of us today?
Well, I grew up in real estate. My mother was a single mother,
Microphone, just
and she worked. Pardon me?
a little closer to the microphone, please.
Yes. My mother was a single mother, and she worked in real estate. Sorry. And can you hear me now?
Yes. Thank you.
Can you hear me better now?
Yes.
Okay. And so I grew up in real estate, and then I worked in commercial real estate in Florida when I lived most of my adult life there. And then when I came back to Tennessee, I've also worked here a total of almost 3 years with Victoria. And I would just like the opportunity to be able to make, gainful employment out of it, because I do think that I want to make a career out of it. And so that's when I decided to make the decision, to try to go ahead and pursue my license. I have 2 college degrees, but I really enjoy real estate. That's what I do. That's what I use my degrees in real estate for marketing and the lead conversion and whatnot. But I really think that I'd be a better asset as a licensed agent. Sorry, not a broker.
So, Ms. Copeland, we have limited information about why you had to come before the commission today. Apparently, there was some criminal issue in the past of some sort. Would you mind describing what got you here?
Yes, I have. I had a substance abuse issues in the past where I'd had surgery and I became addicted to painkillers and then got addicted to prescription medication. And I struggled with that for years. And then I got free. I lived in sober living for a year. And there's a letter in my application from the graduation where I graduated sober living. And then, also, I got saved. Well, I was already saved, but I got serious about a 12-step program and have been, doing a 12-step program since June of 2004. 2014, I'm sorry, 2014. I'm nervous, sorry.
It's okay. So the burglary when did that occur and what did it involve?
Oh, that's 20 years, that was 23 years ago. I think that was back in 90 something,
That's
or
right.
94, maybe something like that. I was a kid, and my just some friends, they were in my car, and apparently one of them got pulled over on Jefferson Avenue and had some checks or something in there. I don't know what it was.
Miss-
Christopher Charles was his name. And I got implicated, and I wound up. I didn't plead to that charge. That was a
Copeland.
charge that they gave me because of association.
Okay, Ms. Copeland,
That's
stand
been
by.
20 years ago.
Would you stand by just for 1 minute? There may be a reason why we don't need to discuss that burglary.
That charge wouldn't be relevant because it's past the 10-year mark. So just in consideration today is a theft charge and a drug charge.
Okay, so the distant burglary charge is off the table as far as discussion. We don't need to hear any more about that. Apparently, there was a subsequent theft charge. Can you tell us about that and
Yes.
when that occurred?
Yes, that was. I don't know the exact date that occurred. That's been a few years ago, and I was actually taking some gentlemen to a sober living residence. And whenever they went in, they wanted to stop at the store to get some hygiene items or something. And when they went in, they wound up running out of the store. The two gentlemen and the cops came, and I had a bit of a record, and I only knew their first name, and so I wound up. There was some hairspray in my car or something. I wound up, but I wound up getting I don't know what you call the plead for that, but it's something withheld. It's on my sheet there with the way it was a misdemeanor, and it was not I forget, but it's some legal term where you're actually not deemed guilty or something, or it's not taken as guilty, or it's not a guilty plea.
And then, if you could, regarding the pain pills, what was the issue there?
Oxycodone was the issue. I had some surgery done that was elective surgery, and they put me on that prescription medicine. I didn't realize that. I thought you had to inject something to get this medication. I had no idea that you could do something by taking it by mouth, and I did. Really quickly, actually. It didn't take months. It was definitely weeks. I'd say it was a period of probably about 4 or 5 weeks. I really couldn't function normally without them.
Hey, commissioners, do you have questions for Ms. Copeland? Ms. Franks?
Good morning, Ms. Copeland.
Good morning.
I wanted to ask, so the Xanax charge, that was in 2015, correct?
Yes, ma'am.
Okay, and then the theft was in September of 2019, correct?
Yes,
Right.
yes, ma'am.
All right, so that was 1 year and 10 months ago. I'm also wondering, you said that you had a license in Florida. What kind of license did you have in Florida?
No, I didn't have a real estate license. I leased a commercial office space. The owner of, he had 11 high-rise buildings, but I worked at 2 of them in Clearwater, Florida. It was called Wilder Corporation. So I was in commercial real estate, but I didn't have a real estate license.
Okay.
And you're required to do licensing to do leasing it to work for the owner.
Okay. So, what made you choose the company that you're going with?
My mother knew her very well for years. I knew that she was a Christian lady. And then I only came to work here temporarily. Someone had went on vacation or something. So I came just to work temporarily, and my plan was just to stay for a little while. But then when I came, it was such a good fit for me and for her. And I don't know why I never thought about being in real estate, because my mother was in real estate. It never had came up, but I just really took to it. I mean, I had done commercial real estate, and I grew up listening to my mom do residential, and so it just became something that just never ended.
Okay. So, so how long have you worked at that real estate company?
The first time I worked, the end of 2017 through 2000 and what was it, June of 2018, something like that. I worked about a year and a half, and then I came back. This time I came back, I was started here in December, I think, of 2019.
She went back to Florida for a temporary period and then came back.
Okay. So, Miss Copeland, so you were working for the principal broker that you're going to be having on both these occasions when you were arrested. Is that correct?
No, when I went back to Florida is whenever I got that when I got arrested. When I left here and went back to Florida.
Okay, I see that now. But so when you got arrested in 2019, were you working for that principal broker then?
No, ma'am.
How long have you been back to Tennessee?
Since October of 2019.
Okay, that's all the questions I have, Mr. Chairman.
Thank you, Marcia. Other questions? Steve, Gwen, Commissioner Gwen.
Yes, maybe this is for Caitlin. The judgment on the theft was September 23rd, 2019. So if she had waited, she wouldn't have to be here if she'd waited until September 24th. Is that correct?
It's a 10-year. We do a 10-year look back. And so we're looking
I saw
at
the 2-year.
no, 2 years. There is something about 2 years past probation, but that's actually a provision that's being removed. So we do a 10-year look back on any felony charge or any type of theft misdemeanor that's directly related to the profession.
So what does that say then? Rule 1260 shall be
think-
eligible for examination
So
unless
it-
2 years have
Past probation.
probation. Well,
So I can give some context. So this is the rule that is being amended in accordance with the Fresh Start Act. We're going to be before the Joint Government Operations Committee this month. So what you're talking about, the 2-year look back, previously there was a requirement that you had to be 2 years past a guilty conviction, probation, or release from incarceration, whichever is later in time, before you could sit and take the real estate exam. So we found out that was too restrictive. So the amount of time that we're looking back for regarding the different convictions, whether it's a theft, a misdemeanor theft charge or a felony charge, is going to be in the past 10 years. So in order for this conviction would fall in that 10-year period. So does that provide you more information?
yeah, but it's almost outside the 2-year
Right. The 2-year
period
the
anyway.
2-year period, yes, it's right outside of that, but we look at all convictions or guilty pleas in a 10-year period. So that's the only time frame that you really need to be cognizant of. So if the this offense occurred in 2010, she would not have to appear before the commission. But since it happened in 2019, that would be any conviction it would have to be 2029 before
Right.
she would not be able to appear.
Right. 2 years is really not relevant then? Is that what you're saying?
Right. So previously, that's the rule stated that the 2 years was relevant. But since we are amending the rule because that restriction is too restrictive. So beginning, I believe it's August 5th, is when the rule goes into effect. The 2-year period will no longer be there. So you'll
Alright.
only be looking for 10 years.
What this was saying was that you couldn't even apply. You couldn't even sit for the exam unless 2 years had passed from your probation, incarceration,
right.
conviction, all of that.
Right. So it's just a complete bar. Like she wouldn't even be able to submit an application.
Thank you.
Okay, other questions? Ms. Copeland, I'm sure you stated this, but what item or items were included in that theft in 2019?
Hairspray.
Hairspray? That was it?
That's what was in my car, sir. Yes.
All right, thank you. Any other questions for Ms. Copeland? And of course, you can come back if you'd like to. At this time, Ms. Carmack, we'd like to turn our attention to you for a moment and ask you to tell us why you're interested in having Ms. Copeland as an affiliate with your company.
Well, as Shelley had stated earlier, she came to work for me to fill in for one of my employees that was on vacation. And she was just going to work 20 hours and help me work with database. And then when the guy decided he wanted to go from full-time to part-time, so she stepped in, and then eventually he left because he just floated around from office to office. And we connected amazingly. So I am very an exhorter and an encourager. So not only did Shelley and I work hand in hand together and fit amazingly, we knew each other's thoughts and the process. And so I'm very high A energy. And so many times explanations in a fast pace doesn't happen, and she could just pick things up. And within 2 months of her being there, I almost doubled my contracts because she's amazing at follow through and communication. And so over the years, she's just became better and better and better. And we just flow well together. And my heart for her is to have the opportunity because she's very aggressive. She's a self-starter. She has more than paid her price. I experience every day with the depression and the guilt that I don't want her to walk under. And so I have encouraged her for years to attempt to try to get her license because she is trustworthy in our company. She's a great leader, and she helps oversee all my in-house staff. She's amazing. She's simply amazing, and she loves people. And she just wants to make a difference. So her heart now is not only to do a 12-step program, but to facilitate one. And part of being in real estate is to put that money back and pay it forward. That's her goal.
Commissioners, Ms. Franks.
Good morning, Ms. Carmack. I wanted to ask you, how many agents do you have at your company?
7.
Okay, 7 agents. And can you tell me a little bit about your training program, what you will be, how you will be training Ms. Copeland?
Well, we do hands-on. We'll go through contracts classes. And as an admin, she knows how to do lots of that already. But more than anything, when people come to work with us, it's one-on-one. We'll have sit-downs, and we'll go through negotiations. We'll go through contracts, and for as much time as needed, agents can ride with me, and I just split whatever contracts that we get because once they learn, it makes them a better fit for our business.
It makes me feel good. I have a small company too, and I am able to give more hands-on training to my small company versus maybe a larger one. So that sounds great to me. That's all I have.
Okay.
Other questions, concerns? If not, commissioners, is there a motion? Ms. Franks,
I'd like to make a motion that we grant this approval for Miss Copeland.
seconded by Mr. Diaz. Discussion. All right, the motion on the floor is to allow Ms. Copeland to go forward and get her real estate license. If you're in favor of that motion, you get to vote yes. If you're opposed, vote no. All right, are you ready to vote? Let's do it then. Those in favor of the motion vote aye.
Aye.
Those opposed vote no. And that motion passes. Ms. Copeland, make that broker of yours proud.
Thank you. Bless you.
Take care and good luck.
Thank you.
All right, next up
Hallelujah.
is a waiver request. Just out of curiosity, what can they see? Where's the camera?
So, as far as the web, we are streaming the meeting live, and so from
Always this.
correct. Are you worried about an angle?
Back of his head.
There- People are wondering what the sideshow is over there.
Oh my God, what is that bright bulb there? All right. Tricia Hardaway.
Yes. So each three of these I will be presenting to the commission. We don't have the actual requesters here. And the first one is your typical medical waiver request. This licensee expired in December of 2020 and has been licensed since 2006. The E&O she does need to obtain, and firm license is active and education is completed. She is requesting a $500 waiver of the late fee, and you will see attached a letter from her as well as a doctor's note.
Move to approve Miss Haraway's request.
Second.
So I have a motion by Ms. Frank, seconded by DJ, that the request be granted. Is there discussion? What caused you to make that motion without us even talking about it?
Because it was COVID related, and COVID could be anything from a light case to a hard case, and I just feel like we need to give her some grace because of that.
But she had like 2 years beforehand to renew, right? I mean, if it's a license renewal.
Most people don't renew 2 years before. I mean, I do it the week of usually. So
Well, but 6 months, but when do we send that notice out? Is it 3 months in advance?
90 days.
90 days.
So about 3 months.
let's just be nice.
I know you're being nice, and I know you're a nice person. I was just curious. I don't want this commission to get the reputation
Of
of
being nice.
necessarily nice. All right, any other discussion? All right, if you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. And the motion passes unanimously. Next up is Aaron Fowler.
Okay, so this one is a little outside the typical medical waiver request, but we have been receiving this type of request, and it is medical related. It's related to E&O though. So let me make sure I have these in order. So this licensee was suspended during our 2021 E&O suspension, which ran on January 29th. As of 5/5/2021, this licensee has obtained E&O, and so this fee request is a request to waive the penalty associated with E&O due to health reasons.
I also noticed there was no letter of explanation with this waiver.
Oh, I actually noticed that as well, and those are upstairs on the printer.
Okay.
She did submit it
Okay.
just reminded me of that. I could read it if you would like.
Nice guy here.
How long is it?
5 sentences.
Yeah, I'd like to hear it.
Okay. The reason there was a lapse in my insurance coverage is because I suffered a miscarriage in December 2020 and went into a severe depression. I have been unable to work and are unable to pay reinstatement fees. As you will note on the letter from my OBGYN attached, I have been under his care for all issues resulting from the miscarriage. I might also add that I never received any kind of notice of this via mail or email, nor did my broker, Tracy Adams Realty Group. My insurance is now in effect. Please let me know if there's anything else I can provide. So she actually hasn't missed her renewal. Her renewal for her license is not until October 13th, 2021. This is in regards to the E&O penalty. So as part of the law, all E&O or all licensees in active status are required to maintain E&O insurance. And when they don't maintain it, then their license goes into a suspended status. Once suspended, they have 30 days to obtain the E&O without penalty. We send a letter on the date of suspension to their principal broker at the firm, the licensee at the firm, and then the licensee at their home. And after that 30 days, after they've been suspended for 30 days, is when the penalties start to accrue. So there becomes a penalty fee of $200 if you backdate and have continuous coverage, $400 if you do not backdate and do not have continuous coverage. And then once you've been suspended, I believe it's for 6 months, then the penalty goes into $500 with $100 for each additional month. So it can get up to, I mean, if you have your E&O suspended for over, close to that year mark, it can get up to almost $1,000. And then the principal broker is also penalized for that failure to supervise and ensure that their licensees had E&O. No, because I don't know the exact date, but E&O is 2 years as well. And sometime within the past, the commission changed all expiration dates were December 31st, I believe. And then they changed it to be related to the date that you were licensed. So all of our renewal dates are throughout the year based on that initial licensure date. And E&O for about 80% of licensees runs January 1st of 2021 to 2023. So it's every 2 years.
So how many dollars are we talking about?
She is asking for a waiver of the $500 penalty.
3 months? Is that basically the
So
penalty?
she obtained her E&O on 5/5. So it went up to $500 at the beginning of May. She has it now as a 5/5.
She has her E&O as a 5/5.
Yes, she reinstated her E&O on May 5th.
Okay.
It expired. I'm sorry, one more time. What exact date did it?
So most of these, I'd have to look, either expired on January 1st or January 15th. That's based on the E&O policies. We did not run the suspension until January 29th to just make sure that everybody we were suspending truly did not have E&O.
It was in that December.
Yeah, it would have expired in January.
Commissioner Bagley, can you make sure that your microphone is on when you're speaking? Thank you.
Okay. I'll make a motion that we approve.
Second.
Motion by Mr. Bagley, second by Mr. Ferris, that this licensee's request be granted.
Question.
Further discussion. Steve?
Where does the money go to, Caitlin? The penalty money? Is it state of Tennessee, or does it go to insurance companies, or both, or what?
No, the penalty fee would go into, I don't know exactly, but it would either go into sort of the licensing fees or it would go into our, I believe the line item is, I believe it's like a regulatory fee.
Do most people that get suspended go ahead and pay the fee and move on, or do we get requests from a high percentage, or do you know?
I know that we hear from a lot of people about E&O, and I can tell you the last 2 renewal cycles, we have followed exactly what the law and the rule says. And I can't really speak to prior to that, but we have heard from a lot of principal brokers this time around in particular, because they also get penalized if their licensee fails to maintain it. And so honestly, it seems like we hear more from the principal brokers than we do from the actual licensees. The licensee will typically get the, pay the fee, and then that generates the complaint against their principal broker. And those are the agents we normally hear from.
Trying to get a sense if we, when we waive something like this, is it abnormal, or do people think, well, I'll let the thing slide and they'll waive it, and so the penalty's not really doing all that much?
I would say this is abnormal in that we don't really have any other avenue for these agents besides bringing them before the commission.
It's not like the rules are clear, correct?
Yes, the rules and statutes are very clear about E&O, and this is a cycle that happens every other year. And like Caitlin said, we get a lot of questions from principal brokers, more so than we do get questions from affiliates. And we have followed the different communication processes. If a license is suspended, we're required to send a letter to the affiliate broker's home address, their firm address, and then to the principal broker and also at their firm address. So all 3 of those communications are required to go out. Rice also contacts all of the licensees according to their contract, or whoever the insurance carrier is there. So they're seeing communications from us and communications from the insurance company. So a lot of people most affiliates comply and pay the amount of money, but if they would like this information, like the money waived, it's within your discretion to do so.
Right. Okay, thank you.
So does the principal broker, whoever this principal broker is, were they also assessed a $500 penalty?
So a principal broker, the civil penalty amounts for them vary. So for this particular one, I believe this civil penalty for the principal broker would be $1,000. So the amounts are either $200 if it's backdated within the first 120 days, $400 if it's not backdated within the first 120 days, and then after that point, up until after that point is $1,000 for principal brokers.
And that has nothing to do, if we allow this person to get the waiver, doesn't affect the principal brokers.
Right. No, it's
Okay.
not going to, because the civil penalty that is assessed to the principal broker is connected with the failure to supervise, which you're required, principal brokers are required to make sure that all of their agents maintain continuous coverage and provide that proof to the commission.
So was the principal broker, have they reached out and said, hey, we dropped the ball on this too, or?
I'm not sure about this particular situation, but I can tell you from working this cycle and the previous cycle, most principal brokers, we get pushed back a little bit on it, but it's pretty clear. It's either that your agent had insurance or they didn't. And so there's the principal broker can also, if they wanted at some point, to request a waiver, but that again, that's not typically how the process goes.
And I want to take the opportunity to kind of applaud the firm I am with, because they go really over and above trying to convey, calling us, emailing us, saying, hey, make sure. Of course, I take an interest in it myself, obviously. So I'm obliged to make a motion to,
We've already got a motion.
I'm obliged to second and vote yay then. But any rate, just a thought, because I feel like the broker where she's at could have stepped in and said, we have interest in you getting this as well. Don't wait till May.
Yeah, I require it
Right.
before. I require it, and it's in each of my files for each of my people.
Yeah.
I still do paper.
And just as a follow-up, if you go look at the DAR report, which stands for Disciplinary Action something, it's DAR report, okay? Or in Caitlin's latest newsletter, there's disciplines this commission has put out there, and there are dozens of principal brokers who've paid the price. If it's my office and my agent causes me to have to pay a price, they're going to pay
They're going to
double.
pay that one too.
They're going to pay that one too. Or their license is going to be sent back.
Right.
In any case, the motion on the floor is to grant the request of this licensee. Is there any further discussion? If not, if you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. No. That motion passes on a 6 aye, 1 no vote. Mr. Glenn votes no. Further discussion? I think we have a presentation coming up, and why don't we take a 10-minute break, and we'll come back with the ARDA presentation. Okay, so mainly because we're glad you're back. Ms. Maxwell, you want to make some introductions, and we'll get on to the next part.
Yes, so we're going to skip ahead to the ARDA presentation. So based on the Commission's never-ending questions for our timeshare appearances, we thought, why not invite ARDA here to really give us the official presentation and to come from a perspective of every development as opposed to maybe what one does that's here. To my left, your right, we have Elizabeth and Robert from ARDA, and they're here to give a little presentation and maybe answer any questions as long as the Commission keeps it within their knowledge base.
But what does that acronym stand for?
The American Resort Development Association.
It doesn't say timeshare in there anywhere.
Does not say timeshare.
Okay. All right, Robert, are you spokesman, or Elizabeth?
Well,
are you the
I think
spokesperson?
we're going to divide it up. She's going to kind of start, and then I'll take over.
Have a PowerPoint behind us. Once again, I'm going to move where I can see it.
Just make sure you're read. Yep. And if you're read, and that goes for anyone speaking. If you're read, you're heard for the recording. And yeah.
Thank you. I'm Elizabeth Baker. I'm with the American Resort Development Association. Thank you so much for inviting us here today. By way of background, I have been in the timeshare vacation ownership business for a number of years, which include stints as a regulator in the state of Florida, as well as working for a small independent developer and a very, very large developer. And I have been with ARDA now for about 2 years doing regulatory outreach and state regulatory affair work based in Orlando. So just going to go through some highlights, and we'll certainly hopefully have some time for questions. The American, let me see if this is going. There we go. Okay. So briefly about ARDA, we are a trade association for the timeshare industry. We've been around for over 50 years. Our main office is in Washington, D.C. Robert and I are with the State Affairs team based in Orlando, Florida. We have a variety of members. I don't know the exact number, up close to 1,000, upper hundreds of members that represent all aspects of our business, which include developers, suppliers, managers, HOAs of timeshare. Our primary purpose, is for legislative advocacy, and we have contributed to legislation in more than 29 jurisdictions in the past few years. Okay. Another arm that we have in our association is the Resort Owners Coalition, and that is the arm that allows individual owners to contribute anywhere from $3 to $5 every year to help advocate on behalf of owner issues. And many of those, sometimes they do include developer issues as well. The large issues that we typically look at do include property taxes. Those affect everyone. Oops, excuse me. Another arm we have is our ARTA International Foundation, which does research, and some of the information that I have today is information that the foundation has compiled. So typically, the timeshare industry today, we currently have 1,570 resorts with 205,490 units and 9.9 million owners. This is a graph that gives you a show of the sales annualized over the last number of years. You can see the drop there towards the last drop obviously is the COVID drop. The next to the last drop is the 08 recession, and you can see how we had rebounded, and then of course COVID has put a detriment on that this year. Certain trends to look at, though, over time, the past few years are, again, how the sales volume has continued every year, again, this last COVID, while occupancy, remains relatively steady, and the maintenance fee and sales prices. I'm sorry. I hope I can go back. This one?
The average maintenance fee billed is that?
Yes. Yes.
Average sales price. Average sales price is for.
Right, a week equivalent. Mm-hmm.
So on the back to that maintenance bill, so that's for the whole unit. That's not per person.
So that is for the individual owner. It's an average per week. So an owner is responsible for paying the maintenance fee, even if they're not occupying the unit.
That average maintenance fee is per week. So if a person has 3 weeks, it's that average times however many weeks.
Correct. And an unsold inventory, depending on who owns it, either if it's owned by the association or the developer, then they're paying the share for those weeks. The latest economic impact survey we have from 2019 shows just some general figures of what the timeshare industry accounts for, over 612,000 jobs, and we provide over $12 billion in taxes. This is just a breakdown of the number of resorts in the various states, and you see that Florida obviously has the largest number with 373. And your fine state of Tennessee has 33 resorts. And as a total, that is 2% of the total number of resorts and 3% of the total number of units that we have. This is some background information again from our foundation on the typical timeshare owner. I don't know if you want me to read through every slide, but primarily they are homeowners and college graduates with a median income you see of around 62,500.
Where did you get the satisfaction?
It's from the survey. They do a survey.
Ernst and Young, right? Probably UI now every year. That's a survey.
Satisfaction based on product or based on the, how did you get that satisfaction? Was that based on the product?
Yes, based on the product and their use.
Okay.
This is just a brief slide showing the attributes that the owners prefer in making their purchase. Again, it's higher number of bedrooms and the room layout, kitchens, and things that are not always found in your standard hotel room. So the legal structure in timeshare, just as many things change over time, such as technology and the fact that we're able to have a meeting via Zoom today, the timeshare product has changed over time. Initially, when it started, most of it was the specific, you bought the 1 week and that was your week. And now more often it is, the property is held in a trust typically. And so the individual who's purchasing is buying a beneficial interest in the trust that's attributable, has a point attributable quantity that they may use for different room sizes, different room types, different locations, again, just all with their number of points. This is just I can probably skip this slide, a breakdown just that shows typically, you used by weeks, and seasonality is one of the indexes that determines perhaps price and availability, as well as location. Again, now the more common use now is for points. Each unit will be assigned a number of points that the developer would sell, the point quantities that vary. One important thing to note here too is different developers will have different point quantities that they assign to their unit. That's one thing that does make it a little bit more difficult in the regulatory environment today, when it used to just always be a week and everybody knew it was a standard week, because Disney will have a point attributable to a unit that will be different from what Wyndham assigns or different from what Marriott assigns, yet it's all for the same product. And again, just another example of how a purchaser can go through to different locations through their individual company, or they can also go through an exchange company, which is an external company. The two common exchange companies are RCI and II. And another important note here is that when the purchaser deposits that's what they call a deposit, places their ownership in for an exchange, the exchange company may also have a different point valuation assigned to it in their system for redeeming it. So just another thing to make it a little bit more complicated for people. This is our slide highlighting just resort management and control. Many of the resorts are still managed by a company that could be affiliated with an individual developer. You see that 26% are by excuse me, a third-party management company, and then 4% are still self-managed by individual owners. And the management company has multiple responsibilities. One of the main things they do, in addition to managing the reservations, is also the collection of the property taxes and remitting those to the various tax collectors. This is a further slide on the average maintenance fee that, again, just shows the breakdown of the average depending on the unit type. We work on many of the issues that we work on have come from various consumer concerns, which include the fraudulent resale and transfer companies, the need to maintain consumers' privacy, older legacy resorts that have owners who are oftentimes abandoning or leaving, and how to help those resorts figure out what their next step are, and the changing product and regulations, and trying to ensure that we can keep regulators educated on the changes, but still seeking fair regulation in all jurisdictions. Now I'm going to turn it over to Robert, and he's going to go through a little bit more about some of these consumer issues.
You guys have any questions up to this point about any of the product or use?
I mean, I hope I didn't go too fast.
I've got a few questions, but we may want to wait until we're through the presentation.
Whatever you want to do.
But what's your pleasure?
Either way, I mean, we're happy to do whatever you guys prefer. I'm going to go into some of the what I think everyone, I presume, in exit, a little different than product mix, point system. So I thought it might be an opportunity to ask some questions, but I'm happy to go ahead and plow ahead.
Marsh, you want to go ahead and?
Yeah. When they do, I've never owned one, so I'm not sure. So when they do these assessments, do they have like restrictive covenants or something that says how often they're allowed to do assessments at each of? I know it would be site specific probably or development specific, but do those usually tell you how often assessments can be made?
So the maintenance fee consists of all the things that are typically required to operate, just the same as if you owned a whole condo or your own home. Utilities, maintenance, housekeeping. It's done once a year. Now, if you're asking about a special assessment, that every resort could have underlying documents that may spell that out, or it could just be on an as-needed basis. One of the issues could be if a fire damages whatever may not be covered by insurance.
Or if you have to have a new roof on the huge building or something is what I was thinking.
Many jurisdictions require reserves that are a component of that maintenance fee. And so you're putting a small portion into the reserve fund every year that will cover that expense.
And then the other thing was you said fraudulent resale and transfer companies. So is there a lot of that going on? I haven't heard of fraudulent resale companies.
Oh, yeah.
Robert's going to.
Okay. If you're going to go over that, then we can.
I'll go over that and have to answer any other questions. But I'll definitely address it.
Okay. Can y'all see the board with me sitting right here? Okay.
One quick question. So you said in Tennessee that 33 resorts belong to ARDA. Out of how many do you think? Do you have every resort? Do you have 50% of resorts, or how many are members?
So the resort isn't necessarily what's the member. There's a developer who developed resorts, built resorts. There's management companies. This is from the surveys that our foundation conducts to determine the number. So it's not necessarily that the resort chooses to join. It's that we have found that these are the numbers of resorts in the state.
And you may have a developer that owns multiple resorts around the country, like Wyndham, has resorts, Marriott.
Wyndham has a lot of resorts in Tennessee.
And then you have something that I think is important for everyone to understand is you have, there's a distinction. I broadly say there are basically two classifications. One is developers and resorts in active sales, and then resorts that are sold out and there's nobody left. It's like, a neighborhood where you live, and what's left is a homeowners association. The developer's gone. And the reason that's an important distinction, and I'll address it as I go in my presentation, but so to address your question to a degree is, if talking about assessments, where it's sold out, it's owners make that decision. If they need a new roof or you want to refurbish the pool or whatever, that's owners. Whereas what Elizabeth alluded to a little earlier was if the developer's still involved, the developer may have to pay some of those things as well. But and there are other important distinctions, like if someone wants to get a developer in active sales, it's still around. it's much easier for them to take inventory back and resell it. Whereas a sold out resort, I mean, there's not really anyone to take it back. The homeowners association could, but that then impacts their ability to cover, annual expenses. So hopefully.
So if I was in the market for a timeshare, would I be smart to look for the ARDA membership?
So
logo?
Obviously, this is self-serving. But the reality is, it's true, and the reason why that's true and so important is, number one, to be an ARDA member, you have to agree to comply with our strict code of ethics, and we have an ethics committee that addresses consumer complaints, member complaints, and violations of our code of ethics. So there are timeshares that are not part of ARDA, and I would suggest that many of those have had problems, and that's one of the reasons they're not part of ARDA. But yeah, so I think you should. There's lots of benefits to buying and owning a timeshare at a.
I think it's also important to mention in that regard that we have also take action may be too strong, but cease and desist we have pursued if companies or entities are advertising and using our logo that they are a member when in fact they are not.
Which is a great point. It tells you how important having ARDA's logo associated with product, because every week, and it's not an exaggeration, we find somebody trying to use our ARDA logo saying they're a member, and we either have to. It's full of approval.
One more question at the moment. So you talk about points, and it's like you're selling points, correct? So why does the real estate commission have to be involved in that?
The points are still attributable to a piece of real estate.
But the real estate is currently going to be likely in a trust. Is that right? Is that who owns the real estate?
Most likely it will be deeded in the same way that in Nashville, a country music singer or a professional sports athlete will oftentimes have their residential property held not in their own individual name, but in a trust. So it's a similar kind of setup there.
And just so you know, the evolution of why most of the major developers now put all the real estate in a trust is because owners wanted flexibility. And so by having a trust, a land trust, basically own all the real property, then an owner who buys points can use any of the resorts that are part of that trust, and even expand it further by using the exchange companies RCI and Interval International. That's really the evolution, is because it provided owners wanted flexibility. So it evolved into this trust-based product that then allowed the points to apply to resorts all over the country.
So I've always pictured like 50 warranty deeds for 50 weeks sold of a particular unit. Is that the wrong picture today?
Well, I'll go ahead.
It's not the wrong picture, because in some places that still may be the case. And again, in a sold out resort, that could be the case where every one of those owners still received a deed. But it's more so now, newer developments are going to this trust-based product. Again, it's owner flexibility. It allows for, again, on the exit side, it allows for an easier method too of disposing of that inventory than when you have the deeded real estate. And I do think it's also one important thing to mention is that not all states regulate timeshare through their real estate commission. So it's different in every state, and the developers and the people who are creating these various programs have to comply with the different laws in all of the jurisdictions. It's not always real estate.
That's
Questions at this point? So, yeah,
Affairs up to 500 or what?
so I'll answer it this way, and then certainly feel free to weigh in. Doesn't matter size. We have the membership dues are based on size, but we have tiny, one property timeshare developers and sold out resorts up to the biggest in the world. So I don't really know the percentage, but I would guess that over 80%, 90% would be members of ARDA. It's not just developers. It's like sold out resorts. You have the management companies that are part of it. You have ancillary services that are part of it. I mean, it's not just developers. It is timeshare and everything related to timeshare. So
Linen services. Visit that.
Banks and lenders that are service our industry are part of us, our association as well.
So the trust back.
It is. Most of them are.
The trust would have to have a trustee. Is a trustee person?
Developer. So
And that's a fiduciary obligation. The independent party has fiduciary duties, both to the beneficiaries mainly, but fiduciary duties with respect to anyone involved in that trust.
So attorneys and accountants, maybe.
Mostly, I believe, it's title companies. They also have a function as verifying
All right, let's go ahead.
So I'm going to talk to you a little bit about, and I know there was a question about the fraudulent resale issue, and a little bit of evolution. Back in 2012, I was working for the Florida Attorney General's office, and I was doing unfair and deceptive trade practice work. And in 2012, the Florida Attorney General's office had 13,000 consumer complaints about fraudulent resale practices. And our next highest category was debt collection, was about 3,000. So it kind of gives you a flavor of how big a problem this was. And so Florida, I think, was the first state to pass legislation about resale. And then and ARDA was involved in that before I was, and then I think we got it passed in 12 or 13 other states. And you saw a precipitous drop in resale problems at that time because it was a very common sense approach to it. At the time, resale, there was no specific regulation or legislation in the country for resale. And so you had resale companies taking big upfront fees and telling owners, well, I've got a buyer for your interest, when there was no buyer, saying, I've got someone who'll buy it for $50,000 when they didn't exist, or I can sell this 30 days, we can sell it. And they had no track record of that at all. So the legislation that was passed put very common sense things into place, like if you take upfront money, you got to put it in escrow until you deliver the service, which, realtors can appreciate big time. You got to put that money in escrow and protect it. So once that legislation got passed in various states, it really dropped. And then so that there's a few still resale scams out there, but for the most part, it has evolved into what now is referred to as exit companies. And what you see with exit companies is, and I put some bullet points up there, almost all, in fact, I'm not aware of any who don't take the position that, they say they've got 100% money back guarantee, and most say we can 100% success rate. They all, as far as I know, take very large upfront fees for their.
Talking $50,000 upfront fees.
Some, I would say it's probably around, average is probably around 15,000, but we've seen 80,000, 120,000, unbelievable upfront fees. And you've got the same issue. There is no specific regulation right now in the country that regulates the exit industry. So those huge upfront fees are not required to be put in escrow. And I'll tell you why that's so important as we move along here. But most of them, once they sign somebody up, they tell the owner, stop making your mortgage payment, stop making your maintenance fee payment, and no longer communicate with your developer, HOA, or management company. We'll take care of that for you. So it's a great way to keep the owner in the dark. And they all say that it's going to take some period of time. 12 months, 24 months, 36 months. We've got ones that are, say, 4 years to get you out. And that has no relationship to anything. I mean, it's quite frankly very clever because it gives the exit company a long runway to hold on to this money and not have to deliver a service. So, and one, I think, important aspect is that they in fact, I don't know of any who inform a consumer when they sign them up that, hey, you can go to your developer. They have an exit program that doesn't cost you anything. Excuse me. So, in my view, from a former, AG's perspective, I think that's a material omission. Not to say that, hey, you can just go to your, you don't have to pay me $5,000, $10,000, $20,000. No, you can go to your developer. They very likely have a program that'll let you out for nothing. And as I put up there, my view is that the unspoken goal is for the owner to default and there be a foreclosure. Many of the exit companies actually put in their contract that a foreclosure is from their perspective, a successful exit. So in other words, I can tell you to stop making your mortgage payment, stop making your maintenance fee payment, get foreclosed, and keep my money because I claim that's a successful exit. And which I think we all would agree is patently absurd. But the other key, and I think it's important for the Real Estate Commission, and Caitlin, you'll appreciate this, that the exit companies, one of the pieces of the puzzle is they have owners send complaint letters to regulatory bodies, AGs and real estate commissions, that are basically written by the exit company saying, something bad was done. And what's curious about it and funny really is that some of these are from owners that have owned for 15 years. They've used it, and suddenly a letter they send to an AG that's been written by the exit company says, hey, 20 years ago you committed some sort of fraud or something. And, but the reason it's important is because, as I'm sure you know, regulatory bodies, AGs, look at the number of complaints and don't always have time to dig deep into the complaint to see whether the complaint is legit. Because if you talk to some of these owners, they're like, well, I was told to write that, and or the exit company sent it in on my behalf. So it's something that affects us as an industry because complaint levels, go up when in fact you just can't take them at face value. And I'm not suggesting that there aren't problems. I mean, listen, our industry has had issues in the past. We don't shy away from that. The difference is we step up, and especially as a trade association, we do our best to address complaints, concerns promptly and resolve things and get them resolved and change practices if it's necessary. Go to the next one. So this is just a little flavor of what's going on out there. The Missouri Better Business Bureau did a great study recently that's quite lengthy and extensive. And, they concluded that the exit companies are really targeting seniors and timeshare owners on fixed income and charging them large upfront fees when most of those people, and I can't say all because, there may be different circumstances, but most of the folks who have owned for years don't have a mortgage. And those are really the group of people that are pretty easy to let out of the timeshare. I mean, it's just not that complicated. But a lot of times the exit companies use tactics that are, put pressure on people to sign up, like your maintenance fees are going to skyrocket. Your kids will inherit this, and, you don't want to burden them. Things that I can appreciate if they were to say to my mom or dad, it would induce them to sign up. And there's just other stories about the timeshare exit scams that are going on out there. And the reason it's so, I think, important to understand it is we're not talking about a few $100,000. I mean, these guys are taking in tens of millions of dollars. This is not a small issue. In my view, it is the largest consumer protection issue in the country right now. Go to the next slide. This is just a little piece from that BBB study that just kind of highlights that the exit companies that they looked at use convincing, often high-pressure sales practices to take payments from trusting seniors across the nation who ultimately receive little or nothing from these businesses. And this is something else we see, that despite the 100% money-back guarantee and other promises, they almost never get any sort of a refund. And that second paragraph just talks about, the age of many of these people, and that they're widows or widowers and military veterans. So it's, it's a real problem that we as an industry are trying to help out with. And I'll explain what we're doing as we go a little bit further. This is just an example of why the fact that there's no regulation on these guys right now can be so impactful to consumers. This is just one company. They did business as Resort Release, and resortrelease.com. And one of the owners had a spouse who created a law firm, Todd and Frankie Davis and Burke, that was set up to work with Resort Release to send boilerplate letters saying, the developer did something bad. And why this is such a big deal is there were over $20 million in upfront fees taken in. When they filed bankruptcy, there was less than $100,000 left in the account, and the owners who paid the $20 million didn't get out. So go to the next. So when they filed bankruptcy, this is just kind of an interesting comments from the judge at the creditors hearing, as is highlighted in that top box there. He says, and this is from the judge, who says that, it appears that business is engaged in soliciting people who own timeshares who want to get out of them with promises that are fundamentally incredible. And that next box says he finds that the business of the debtor, the Resort Release, appears to be engaged in substantial fraud and dishonesty, and gross mismanage it with respect to its financial condition. And what he's referring to about the gross mismanagement is there's less than $100,000 left in the bank account when they took in $20 million up front. So it's just, and this could be addressed if there were legislation out there that said something just as simple as put the money in escrow until you have delivered the service that you've promised. And realtors, you guys know how important that concept is. And the reason I put this one up is Castle Law was in your backyard here. It was set up just to do exit business, and there was a lawyer by the name of Judson Phillips. I think that was Judson Phillips, I believe that was his name. And so he set this up, same thing, took in millions of dollars. Ultimately, he ceased operations. He got disbarred for this conduct, but it was the same sort of thing. All this money taken in up front. Ultimately, Castle Law went out of business. He was disbarred. None of those people got out, and the money's all gone. And he's disbarred. So there basically is no recourse for those people. Let's go to the next one. And then a more recent event was the Attorney General in the state of Washington filed a lawsuit against the Reed Hine Associates, but they did business as Timeshare Exit Team. And at one point, I don't believe they are in this position anymore, but at one point they were the largest timeshare exit company in the country, doing business all over the country, had taken in over $120 million. And so go to the next slide. And this is just the allegations in the lawsuit from the Washington State Attorney General, that virtually every step of the exit process is unfair, deceptive, and outright false. And it just goes on. And what's interesting, you see that they have delivered let's see, it says, I'm at a third bullet point, but Reed Hine, which is Timeshare Exit Team, has only delivered an exit, which could be in the form of a foreclosure, which we talked about, to only half of its more than 30,000 consumers since 2012. And then the next bullet point is that they've implemented this new exit process where consumers negotiate their own exits after paying thousands, which, I mean, that's my point, is up front, they could have just gone to their developer, and that's where we're trying to get people, to do, is to go talk to their developer first. So go to the next slide. Just another example, the Missouri Attorney General filed a case against an exit company, and it just says they took up large upfront money, promised to get a consumer out of their timeshare obligations, and weren't able to do it. They've now gone out of business. Go to the next slide. This is another example where the Arkansas Attorney General filed a lawsuit, got a $500,000 judgment against a fraudulent exit company. Now, the reason I put this one up is simply because I just wanted to show you an example. So Lynx Legal is an exit company that is based out of North Carolina, but the reason I wanted to highlight this to you is, well, first, they're called Lynx Legal, but they're not a law firm. And if you go to their website, it uses lots of terms that make it sound like a law firm. But so they have 100% money back guarantee like we talked about, but as you'll note there, it's if for any reason they're unable to cancel or give back or have your timeshare taken back by the developer in 4 years. So, this sort of thing exists. So they've got 4 years to hold on to your, upfront money and hope in that 4 years that something's going to happen so they can justify what they'll claim as an exit. So next slide. And this is just one other point that I thought was important, because we don't see the level of consumer complaints that we saw back with the resale problem. And I suggest that one of the reasons we don't is because many of the exit companies are using these sort of non-disclosure, non-disparagement agreements that require, when an owner signs up, they sign this agreement that says, you're not going to say anything bad about us on social media or to AGs or to regulatory bodies, and if you do, you breach this agreement, and you minimum $20,000 damages and costs and attorney fees. Now, I suspect that's probably unenforceable. It may be against public policy, but in any case, I suggest this is a reason why you're not seeing as many complaints. And then the other issue would be that may delay this complaint process is if, for example, like Lynx Legal says, I've got 4 years to get you out, then you're not going to have a complaint until after 4 years and they haven't delivered. So it's just an example of, it's a huge problem, but we're surprised that we aren't seeing the number of complaints. Now, I always get the question, and I think it's a valid question, what's the industry doing to try to address this problem? And so back in 2018, I believe is when we set it up, we created the Coalition for Responsible Exit and this website called responsibleexit.com. And we have committed several million dollars, where I think we're maybe up to $3 million in AdWord buys and other social media outreach efforts to try to direct owners to this site. It's a free site, and you go there, and it's as I say, there's dedicated to providing useful information for owners who are looking to safely sell, modify, cancel, or exit their timeshare. So you can go there. There's all sorts of resources and information. Doesn't cost you a thing. And then, as you'll see, the boxes there that are on that homepage are a way to find your developer. And if you know the name of your developer, you can just click on it, and it takes you to a dedicated team that deals with exit and resale. And if you don't know who your developer is, you can go to, it's not shown there, but there's a drop-down list that will identify your actual resort, and then it'll connect you with your developer. So this has generated a huge number of page views, click-throughs to developers. So we think it is a very successful campaign. and we continue to spend money on it to try to get people to go there first and try to resolve their issue without having to pay upfront fees. So, say it again. It is. Yep. The Art of Rock, the Resort Owners Coalition, is on there too, and we have a consumer hotline. So, I mean, I think it was reasonable for any regulator or AG or legislator to say, well, what's the industry doing about it? And we responded, and this has been a very aggressive campaign, but the problem still exists. And, it's hurting a lot of people out there. And, I think it's incumbent upon all of us to figure out what help, especially seniors. But one thing, and I'm sorry I meant to bring it along, but one thing I'd like to pitch to you is we have a one-page consumers can look for. Very common sort of things, don't pay upfront money, cold calling you, it's likely to be, a scam. It's very similar to something we put it, you can find on the FTC's website that dealt with resale. So this has to do with the exit problem nowadays, and I don't know if it's at all possible if you guys have a website, but I'd certainly like to share it with you at some point to see whether it's something you'd like to put on your website. I'm pitching it to attorneys general and real estate commissions around the country. See if they'll update their website to put this on there, because I think it's just very common sense sort of things that I think potentially can help consumers to identify what ultimately could be a bad thing for them. And it doesn't pitch ARDA necessarily. I mean, it talks about our responsible exit at the very end, but the rest of it is just, I think, points that everyone can agree to. So happy to answer any questions you have on anything.
I have a concern, a question and concern that I have is timeshare owners still have a mortgage and they're trying to get an exit plan, and it's difficult to do an exit plan when you have a mortgage.
That's true. So there are, I'd say a couple of things. Number one, if you have a mortgage, there are circumstances where a developer will let that person out. However, it's limited. And, I mean, quite frankly, from my perspective, whether it's right or wrong, it's my perspective on it is, look, you agreed to that mortgage, just like if you bought a car, you agreed to a loan on the car or any other thing. So unless you can show that there was some fraudulent inducement or some other problem that got you into that thing, I don't necessarily see the reason why you should be able to just walk away from your mortgage. Now, of course, there are circumstances where it's appropriate to let somebody out. And certainly if there was some sort of wrongdoing up front, completely agree with you. But, while I understand and feel sympathetic to some of those people, I mean, my mortgage companies aren't going to let me out of my mortgage.
I guess the question would be,
yes,
goes back to resale.
That's right. And those options exist. And if you go to our ARDA website, we highlight a few, I don't know how many currently we have on there, resellers that they're part of ARDA, that we know how their practices are, because you can still go find, if you type in resale, you're going to find people out there saying they're a reseller. And, I can't opine on all of them because I don't know all of them, but there still is a problem out there with resellers, especially a reseller who you call and they say, well, you just pay us a couple of $1,000s. And we can sell it for $50,000 when that's not the case. They just can't do that. So, but that's a problem. I mean, clearly that's an issue.
For the Tennessee Real Estate Commission, I think what we need help with most, as far as timeshares, is that we get complaints, multiple complaints every month. Always get timeshare complaints. And they usually always have to do with fraudulent presentations. And even when we bring in their principal brokers to talk about it, it's like a 5-step process. And so this one did this, and then they pass it to the next one. And it's like, who's the accountable person in this chain? So it just seems like there's a lot of deception. But I've been I think I've been here 6 or 7 years maybe. And from the very beginning, I was told if it's a timeshare, they have got the best attorneys. They make people sign these things. They waive their rights. There's nothing we can do about timeshares. And that is really just not set well with me, because if, we're here, our job is to protect the consumers. Now, I'm a big fan of ARTA, and I know that's what you all are doing also. But if there's any way that we could get any help from ARTA to, just let these people know that it is wrong. It is wrong that they give fraudulent presentations. And I've been laying out at a pool before, and some cute guy comes by, offers me a drink, and says, "You won't go do a presentation? We'll give you a bottle of champagne." And I did it one time, but
Okay.
but
Pretty cute guy.
well, my husband was with me
Oh,
too.
okay, just checking.
But they wouldn't let us out of the room hardly. I mean, we had to manhandle ourselves out of the darn room. So I just think there needs to be, just like realtors, I'm a realtor, it's just like we need to always be increasing our professionalism. And I know that's one of ARTA's missions to help their people do that. But I just wanted to let you know that that's where we as regulators have a problem, is that obviously there's misrepresentation going on, and then their paperwork is such that people have no chance of getting out of them. I also wanted to tell you too that both Arello and ARTA work together with Gary Isom from Arkansas, and we've got put together a video, and it tells you about these scams, how to get out of them. And Anna is on the timeshare committee, and that should be ready for us to put on our website soon too. And I'm hoping that ARTA will use that also. They were paid for a lot of it, so. But I appreciate y'all coming today, but my only thing is the fraudulent presentation is really hard for us to digest.
So I'd just like to add one note to that.
Please, sure, speak.
If I just wanted to add one note to that, if I could, that the unfortunate opposite of that is that all the regulator receives is the negative one.
Right.
And if you, having worked on a developer side before, if you look at the total number of sales presentations that a developer puts on, and you take the percentage of complaints that are generated alleging some form of misrepresentation or misinformation, it's 1%. I mean, it's a very small number. And I know that, 0 is obviously the most acceptable, but overall it is a very small percentage of the number of people that are attending sales presentations. And while the documentation is very buttoned up in many areas, again, it's the responsibility that the developer and the salespeople have to comply with 50 jurisdictions or more, and making sure that everything that has got to be, stated in writing is stated in writing, and, you have to initial for this and that, such that, when a consumer can leave with more information than is truly meaningful to what they're actually purchasing, how much it costs, how to use it, and, some basics.
And if I may add, so we do not at all discount your
True.
concern. I mean, it is legitimate, and if there were a way to make it so that there were no complaints at all, it'd be great.
no.
Now, what I will say is timeshare, and this is with the efforts of ARTA, is highly regulated, and we like that because we want to know what the rules of the road are. That doesn't mean there aren't problems. There clearly are. Now, we really go out of our way to try to help resolve these problems. And we'll continue. And I know we work with Caitlin and others to try to resolve them. We have a hotline that consumers can call. We then put it, pass it on to the developer and try to work with the developer to resolve complaints. I think little by little, you've seen a real evolution in our industry once the major players entered it. Back in the 70s and 80s, before Marriott and Wyndham and Hyatt and Hilton and Sheraton, all the major players got involved, I think there was much more of a problem. Doesn't mean we don't have problems nowadays. We still do, but it is a small percentage, but we're committed to trying to figure out ways to solve it. And if you bring those issues to ARDA, we will do our best to solve it. So I'm not shying away and not suggesting there aren't problems. And we really are putting things in place to raise the level. And one other thing that I presume all of you know is that you do have you have a rescission period in states all over the country. So while it doesn't completely do away with problems, clearly, but it does give people the opportunity to take all these documents, and the documents and disclosures and requirements are, legislated and things we have to comply with, but it gives that buyer the opportunity to go to a lawyer, to go to family members, to go to whoever they want to seek counsel and advice, and cancel for no reason. So it's not perfect, but we will commit to continue to work with you guys and try to help in any way we can.
Jeff.
I just want to add to what Commissioner Frank said about at the point of sale. The concern that I have, aside from the high pressure tactics and all that kind of stuff, is that there's no independent representation for the buyer. There's nobody sitting in the room with the buyer saying, this is what you're obligating yourself to. This is what this means. Here's your rescission period. I haven't heard of a developer exit plan until today. So if there's rescission period ends and you've used it for 10 years and you're done and you want to get out, there's a developer exit plan that you can take advantage of. So I just think from the consumer's perspective, they get that blizzard of information, the bells and whistles presentation from the developer or Wyndham or whoever, and then they get a stack of documents that says these are your obligations, additional years. So they, you walk around that room, you're punch drunk and dizzy, and you have somebody just sitting there, just initial here, sign here, initial here, sign here, and I've sat through a couple of timeshare presentations, and not one of them told me about the rescission period.
Well, so, it's a fair criticism. However, it's in the contract, it's in the documents signed, and you can take all those documents to your lawyer, to your neighbors, to your friends, to your advisor, to your accountant, and exercise your right of rescission.
Right. Well,
so, I don't think, and my point is, and I'm not discounting what you're saying at all, but my point simply is that I don't think if you, for example, analogize it to, go to buy a new car, I don't think you'd say there should be some independent third party sitting in the showroom with you. And I don't think the same thing would apply to timeshare. But whereas in timeshare, you do have this extended period that is set forth in the contract. And that allows you to take some time to think about it, to go talk to your advisors, to talk to your family, to digest what's there. And if you decide that's not what you want, you can exercise that right.
What extent of that rescission period comes to your mind, Robert, when you say that?
For which state? For this?
For rescission period.
Well, it's different in each state. Florida's 10.
We're 10 days.
10.
Yeah, you're 10, but it's
14
different.
if you haven't seen the actual.
That's right.
What's the average, I guess?
In some, it says as little as 5, but the majority of developers who have a product located in Florida typically honor that rescission, which is 10.
Just so I'm sorry to interrupt, but just on that point, to tell you how important our code of ethics is, years ago, we put in our code of ethics, you had to have a rescission period. So you could see the evolution. At one point where it wasn't required in the state by law, a lot of developers didn't have it, but we put it in our code. So now all of our members have a rescission period, and most states now have it in law, which we were behind. And we want that because we to address this very thing that the commissioner just brought up, that, while I don't agree that you should have someone explain it to you, I think most of the developers, Wyndham was pretty good at they actually most of the developers now have a separate quality assurance person that goes through the contract separate from the sales guys. It's not perfect, but we recognize that people get a lot of information at that time. But I do think it is a nice balance to have 10 days to go home and do anything you want with that information. I mean, go talk to your lawyer, talk to your neighbors, talk to your friends.
What trips me up though is that you've already signed the papers. You're already obligated.
No, but you can rescind it. You got 10 years. You got 10 days to sign it and be out.
Well, so you know what? So he really can't do anything about that. So it comes down to rule and law changes in Tennessee if we want to do something about that. So maybe that's something that we need to look at. Because I know we've had people in here before, and when I have asked them, did you specifically tell them that they could rescind the contracts? No, not one person has ever said, yeah, we told them. And the other thing too is I could write something and you probably know what I'm saying, but when I get an attorney involved, you may not know what they're saying. I mean, in using words that you've never heard and stuff like that. And, I think that is what trips up the majority of the people. They don't even understand what they've signed. They don't know to read something before they sign it even. So,
well, we're committed to trying to work with you guys to address your concerns. So.
We're gonna wrap this up. DJ, you have a follow-up question? Steve's got a
I've got
question.
a few more questions.
Yeah, sorry.
Go ahead.
Yeah. Just curious, is the industry growing? What's kind of the health of the timeshare? I mean, I saw the 47% occupancy, which to me sounds like there's problems. And is it growing in Tennessee? We have 33, or is it primarily a Florida thing?
Well, there was a slide there that showed the trajectory of the sales of the industry, and it has consistently grown dramatically. And
But are the sales of existing properties, or are they a blend of new and in other words, what's there now is what's being
I would say
dealt
it's a
with?
blend. Yeah, it's a blend. It's definitely a blend.
And the lower occupancy for the last year was attributable to COVID when, everybody couldn't go to certain places.
Yeah, occupancy is usually over 80%. We're in the great occupancy. Our automatically.
One last question on the mortgages. Are there multiple lenders per property, or is it typically the same lender providing the mortgage, or how does that work?
Well, one property is one developer. So essentially that developer is going to have whoever their lending person is, and that they would be providing the financing if financing is sought by a purchaser.
So you can't go to your hometown bank and get
Right,
a mortgage.
it's not multiple lenders.
can?
You can get your financing wherever you choose. The developer, just like the same way when you buy a car, the car dealership will offer you financing if you want it, or you can have your own. I mean, some people pay cash.
Are there appraisals done on the units, or how's that?
I'm not aware of any appraisal.
Okay.
Hey, DJ,
What's the likelihood of a resale if I have no mortgage? What's the market like? Like I could answer that in regards to a home in Nashville. If I list it today, 97%, you'll have 3 offers in 7 days. Can you have any kind of statistics?
So I think the answer is it depends on where it's located.
Well, that's definitely a big one.
Yeah, because there are some properties.
Location.
It matters dramatically because there are some properties where you can sell it for more than you bought it for. There are some properties you can't give away. And a lot of those are the sold out resorts that, quite frankly, and this is one of the things we're doing around the country, is trying to get legislation allows termination of the. Are some old properties in very good locations, quite frankly, ought to be wrapped up, done away with, sold off for a better use. The problem is much of the timeshare plans, most of the timeshare plans had like 100% voting requirement if you wanted. We've gotten legislation passed in South Carolina, did we get it passed in Massachusetts? In several states, and we're working on others to lower that requirement, because there are ones that, you know, they've been around for 40, 50 years. They're not in a good location. It's not a
Highest and best use.
Yeah, yeah.
And then the only way out in those is that the HOA would be the one that would have to file bankruptcy, you know, and that's been done before in Florida too.
Has there been any interest nationwide to extend the rescission period?
So again, I believe Tennessee has the longest. Is it? I thought it was 15. If you had not seen it.
If you have not seen it, I
It was
think
15.
it's either 14 or 15, and then if you have seen it, it's 10.
And 15 is the longest.
Those are business
Period.
days, I assume.
I don't know if it specifies calendar or business.
I don't think it specifies. We could pull that up, but
But the next to the 15, 10 is the longest, but there are some states where it's 7 or 5.
So you got to get home from your vacation, go to your attorney's office, get them to write you a letter.
And you look at it on day one.
It's me hard.
You're still on the
Of your
high,
vacation.
Yeah.
and you're still on the high, and you've been there for a week, and you've only got 3 days to get home, get to the attorney. That's pretty quick.
They're not the ones that.
And also tell you too, just as a point, that Hawaii is the only state that I'm aware of that requires a verbal disclosure of the rescission. Mhm.
That's amazing to me.
I mean, it's in writing in multiple places,
Right,
and I know,
right.
I mean, they signed so many different documents and received so many documents.
I
but
say
Hawaii's
it's
the only
amazing. I
one.
mean, it's all of our disclosures are in writing, but to Commissioner Diaz's point, there's a greater than 90% of the chance, I don't know the number, the consumer has both a representative and, you know, to use the analogy of this is a trust, I think we have to use the analogy of there would be a benefit for the consumer to have somebody sitting in the room with them. I see your point about the trust. I mean,
Well, and it's,
it's
I
a
mean,
little different than a car purchase.
right.
'Cause
And
this is
right. And from a regulatory perspective, much more, the financial requirement is probably less than a car. Again, depending on what type of car you buy and what kind of product you buy. The average sales price was somewhere in the 20,000s, I think. So for,
That'd be 20 months at $1,000 a month of your fees.
but I'm saying the sales price of a $20,000 purchase, again, on your maintenance fees on top of it, the amount of documents, rescission, disclosure, regulation is more than a car, which costs more, and way more than, you know, when you buy your residence, your principal residence.
all the more reason to have somebody there for the consumer it would be my thought. Yeah.
On those exit things, your biggest hurdles, from what I understood, you're trying to get them to go back to the developer to see what they're thinking. Well, they already feel like they've been misled or tricked by that developer. So for you to say, go back to Jeff, he'll help you out. It's like, no, I think I'll avoid that.
Well,
So the biggest hurdles.
That may be with respect to a small group of people. It's not, certainly not with respect to someone who's owned 20 years, you know, a senior who's owned for many years. I mean, some of these
Silver's
people.
gone by that time.
Well, the developer might still be around, but the original salesperson they purchased from is no longer there. But
But I think
Not all these are paid off seniors. Some of them were
some
owned
but
for 1 year, 3 or 5 years, 6 years, 10 years.
So here's my answer to that. So, and I think it's a misconception that I believe exists around the country, is that exit companies have some magic way to get you out. I mean, they can't. So I mean, but I understand your point, but I just don't want people to have the impression that, well, you can go to an exit company and they can get you out. I mean, they don't, there's no, I mean, you're in legal obligation. They can't wave a magic wand and get you out. Now, if you went to a lawyer and that lawyer had some legal basis to sue, okay, that's fine. But an exit company is not a law firm. And they're basically writing letters to the developer and to regulators saying, oh, something bad happened, let this person out. And they're hoping that they either get let out, that the developer cooperates and lets them out, or that the developer, because they stopped making their mortgage payment and maintenance fee payment, forecloses.
That's my point. On the exit interview, on the exit that you're advertising, you have to say there somewhere that it has to be mortgage free. Somewhere you've got to disclose that, or because some of these people are thinking that they can get out of it and they still have a loan.
Well, yeah, and they can't. And even if it's mortgage free, an exit company can't get somebody out. I mean, the timeshare company has to agree.
But that Arello video that I was talking about, that helps people to know how they can handle it themselves, and it may cost them like $800 versus $45,000-$50,000 to get out of it when you got to get a lawyer and everything else. So it is a plan of how you can do it yourself.
We've shared that video, and then I think we also used some of the tips that Arda came up with just on what to look out for.
Since my time on the commission, one of the very first, and I'm less than a year on the commission, one of the first things that really kind of stuck out to me of our time here with the complaints was the timeshare, and it was really opened my eyes to these. What you say is a very small percent of complaints. I think that's the case, and because the business is so large, there has to be a majority of things that go well with the business. Does not lessen the impact of the percentage that is something needs to be worked on. So, thank you for your time.
Yeah, well, thank you.
I'm very interested in how Tennessee can improve the regulatory process of timeshares to protect the consumer. Yeah.
Well, and one other thing too to add on the complaints, not to belittle that point, but because we've talked about too how these exit companies assist the owners in writing these complaints, the coached complaints, and so sometimes if you look at those, and they could be some of the complaints that are being received too, and you see how similar they are in every scenario. So.
Share one more. I was telling this to Commissioner Gwynn. We were flying down to Florida. I was sitting next to a couple who was well versed in real estate from Clarksville, Tennessee. Very active in their HOA here in Nashville, and a very, very affluent building success. And we just were talking, and the conversation turned to where they were going later this year, and mention of timeshare in Mexico, and you could their feathers just fell. I mean, it's just to me, there's something there that is just a deflating deal, and I know y'all deal with it more than I.
So the only reason I want to comment on that is just the issue in Mexico is a little different, because Mexico has a completely different structure, and we participate. There's a trade association in Mexico. Actually, there's 4 of them, but and their whole model is different. For example, lots of what they call timeshare is an advanced reservation in a hotel. Mm-hmm. So I will tell you, Mexico
different topic entirely.
It's a different topic, and it's not something necessarily we can deal with. They have
I understand.
And in Mexico, the vast majority of the states in Mexico have no regulation of real estate.
Doesn't surprise
period.
me. Doesn't surprise me.
That's correct.
Yeah.
But in any case, thank you so much. We appreciate your time. And again, we're committed to helping if we can in any way.
I'm going to wrap this up with the last question.
Yes, sir.
So back to the exit companies.
Mm-hmm.
I assume, or should I assume, that ARDA has model legislation that Tennessee could enact. So we can't, as a commission, be advocates for legislation, but we are asked about this time of year what type of legislation we would be interested in seeing passed. And I'll bet you this commission would like for timeshare exit companies to have to put escrow funds in escrow. You have that legislation drafted?
And Arkansas has just passed that kind of
Well,
legislation. So
if,
do.
I'm happy to share it with you, and it's passed the House in North Carolina. It's going to go to the Senate next week, and hopefully, like it's going to get passed there. But I'm happy to share it with you. Very common sense.
meantime, does ARDA sue timeshare companies for misrepresentation, or what? How do you guys handle it?
So we do not individually, I don't think we have standing as a trade association. We have a number of our members who have sued and gotten, quite frankly, success, injunctions against that. The problem is there's lots of them. So,
Elizabeth, Robert, thanks for coming. For years, we've kicked around timeshares. We'll keep kicking them around, and we'll keep kicking timeshares. But it's great just to put a face with the industry.
Thank you
thank
so
you so much,
much.
and we're happy to engage in discussions with you guys about anything you're thinking about. Because there are lots of perspectives on it. We'd love to help.
Thank you both.
And we'll be right back.
Is Dinah Burnett?
I'm sorry, I skipped right over that.
She's been there.
Let's go do Dina Burnett.
Okay, this is also an E&O one, but it's a little bit different because this licensee is not asking for a waiver from testing or anything like that, but similar scenario where her license was suspended in March and then did not expire until 2017, and so she was roughly 6 months without E&O, but now would like to retest and reinstate, and is asking for a waiver of that $500 fee. So suspended E&O. So this is dating back to 2017. And so her E&O was suspended. Her license was suspended in March of 2017 and then expired in September of 2017. So she had 6 months in a suspended status.
So this was the case of the lady whose son died, and that she was so upset that she asked her office to take care of putting her license in, was it retirement?
I do know what her son did pass away, and she had a lot of
Trauma from that.
yes, a lot of trauma, and there were other things that happened in relation to that. We didn't include. She did provide full doctor's note and all of that, and medical records, and we just didn't include that just
Okay.
due to the sensitivity of it. And but this penalty was still on her license, and she now is looking to get back into real estate, and is asking for a waiver of this outstanding penalty.
This lady's going to go start over again, and we just have a little cloud on her previous record.
Correct.
Second.
Second.
All right, Mr. Gwynn makes a motion to waive the E&O suspension fee. Ms. Frank seconds that motion. Is there discussion? All right, let's vote. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. And that item is handled. All right, now on to the Education Director's report. E. Ross White.
Mr. Chairman, good morning, and members of the commission. I have before you today the agenda for the July 7th meeting. I would like to say that I've reviewed all the providers, instructors, and courses for this agenda, J1 through J20, and I presented for your approval this morning.
Motion to approve J1 through J20.
Second.
Mr. White recommends that we approve courses J1 through J20. Mr. Diaz makes a motion to accept the Education Director's recommendation. Ms. Frank seconds that motion. Is there a discussion on any particular class? Anyone want to pull one out before we vote? All right, if not, then if you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously.
Thank you, Mr. Chairman, members of the commission.
What about the instructors?
I would like to move forward with the instructor background I have a list of 3 for you this morning. I find them to comport with all the rules and regulations as well, and present them for your approval.
Recommendation is we
Yes.
To accept the
motion by Mr.
recommendation.
Diaz, seconded by Mr. Begley. Discussion. All right, let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Ross, we want to talk about Arello in a little bit. Do you want anything education related? You just as soon say now, or do you want to hold it?
I have several points, but I think I'll hold them in abeyance, and we'll talk about it at one time.
Abeyance.
For those lawyer
For the
words.
time
Yeah, that's
being.
one of those lawyer words again. All right, Caitlin, we're on to your report.
Well, I was going to introduce our newest assistant commissioner, Alex Martin. He has been here now since December, January, over 6 months. But due to COVID, it hasn't been easy to meet anyone. But he is here now, and so I would like to introduce him. Some of you know Alex, I'm sure. So.
Yeah, hey, thank you, Caitlin. I meant to make it down here for the break. I'm not sure I need much of an introduction to this board. I think I know most of you, many friends on this board. I just wanted to pop down and say hello. I think I missed your first meeting back in the office, but we're really excited and glad to have our board members back. Certainly appreciate the hard work that you all do, being volunteers. I know it's at times a lot of time that we ask of you, but certainly appreciate your dedication and your service to the state. As most of you know, before I joined the department, I worked in Governor Lee's office, handled appointments for the governor, and so got to work with many folks like yourself, and had the pleasure of helping recruit some fine Tennesseans to serve on our boards and commissions. So just wanted to pop down, say hello, introduce myself. Really enjoy working with this commission, and Caitlin as well. Certainly appreciate your leadership and your team as well. So thank y'all so much, and good to see everybody.
Alex, where are you from?
I'm from Portland, Tennessee.
Oh, good.
I'm 8th generation.
Okay, great.
Yeah.
Alex, thanks for coming down. You have heard us, I'm sure. You listen in on some of these meetings, don't you?
Yes, sir.
We
Yes, sir.
talk about Caitlin and her staff, and these folks that are supporting her today, and what a great job they do. You've made note of that, right?
Absolutely. I've made note. Thank you, Mr. Chairman.
And you've passed that on up to Toby, I guess, right?
Yes, sir. He's aware.
Well, being aware and getting something done, as far as these are not average employees of the state of Tennessee. They're exceptional and ought to be treated like that.
Yes, sir. I appreciate that. Duly noted. Caitlin can personally attest to this. Whenever I've got some new project that I'm really interested in, Caitlin's normally my first call. So she can attest to that.
We'll watch with interest of your trajectory, because the Commissioner of Commerce and Insurance once was in your place. So good luck to you.
But I hear there's some expectations there. I will have to be careful with that.
Congratulations. Great to see you.
Yes.
Hey, thank you. Good to see many of you as well. Appreciate your work.
Thanks for coming down. All right, Ms. Maxwell.
Okay. Since our last meeting, we have been quite busy. I've been to Jackson, I've been to Memphis, I've been to Arillo. So we did do 2 outreaches, one in Jackson and one in Memphis. So it was great to see those licensees and update them on any changes. A couple other projects I'm working on. We're really making a focus on the distressed counties. That's a governor's priority. And so with Alex, we're planning an outreach in August targeting those counties. So I might be calling some of you, Joe Begley, when we're up in your neck of the woods in August. In addition, there's another distressed county project that I'm working on that would involve pre-licensing for graduating seniors in those counties, and potentially getting them interested in the profession, focusing on economic growth in those counties. Lastly, I was going to go ahead and do my Arillo update. I don't want to steal anybody's thunder, but I did I have it on my report. Hey, I might save you some time.
Yeah.
Well, first of all, I just wanted to say that Marcia did such a wonderful job. As many of you know, she's the president of Arillo. And Joan kept saying throughout the meeting how proud she was of Marcia, and she really did represent Tennessee so well and did a great job. And it was a great first meeting back. Some of the things that I had not heard of that I heard about at this meeting, at the Law and Regulation meeting, there was a lot of discussion on love letters. And the potential for discriminatory practices within those love letters. And Oregon is the first state to pass legislation on love letters, and their legislation banned the real estate agent from having any involvement in the practice. There's also a lot of discussion of acceleration clauses, because I think I think Tennessee isn't the only market that we're seeing increased licensees, short sales, not a lot of inventory in the market. So there was discussion of those as well. And then I also attended, and I'm now part of the committee of the License Portability Task Force. Arizona is the first state to allow a non-resident license. So if any of you decided to move to Arizona, you could easily get licensed there. You just have to be a resident. That does not apply to you living here and then getting licensed in Arizona. And currently Georgia was the only state that has true reciprocity. And their director did speak to that and just spoke to the fact that they're really not seeing any increased violations from those non-resident licensees. And then just the two last tidbits, where Kansas now has a rule requiring email, and it must be updated within 10 days. So I'm kind of looking out to see the language on their rule. And their licensees also have the option at the time of renewal to choose whether they would like to be noticed via email or via mail. And I think that's for any kind of license update. And then it's also for complaints and being served. So I'm going to look to see what they did there. And then lastly, a term I had not heard before was regulatory capture. And that was discussed at the Judicious Task Force. And it's an issue that Alabama had some trouble with this last session. So definitely something to be on the lookout for there.
I think I know what a love letter is in one sense, but in a real estate sense, what does that mean?
So the way I understood it, and anybody feel free to chime in and correct me if I'm wrong, is with the market the way it is right now, a lot of buyers are looking to sort of set themselves apart from other potential offers, and they're writing what you call a love letter to say, I grew up on this street, or I walked into your daughter's room and it's going to be perfect for my daughter, or something along
My Catholic family of 12 children would love to live in your home.
that nature. And there's a lot of concern for, and apparently the people are even doing videos now. And so it was just from the regulatory standpoint, it was discussed about how, you know, it could lead to discriminatory practices if somebody was choosing their buyer based on maybe a factor that was set out in the letter.
Such a lack of inventory, especially in Middle Tennessee, that there was a segment on the news recently of families going around and sending their little 8-year-old daughters to the front door to knock on the door, hand them a letter and say, we want to buy your home.
And one family even said that there was a letter left in the room.
Yes, when they visited, they had a showing, and the homeowner comes home and they find a letter laying on their bed that our family really wants this house. Please let us have this house.
All right, that's it. So it's not considered creative marketing necessarily.
Just a love letter.
Oh, creepy.
It's called creepy marketing.
Okay.
Now, the agents can't control what the buyer does on their own without the agent's knowledge.
Yeah, so the Oregon legislation is directly to the agent. The agent cannot be involved.
And NAR has addressed it too. They're not wanting their members to do it either because of the consequences.
Any questions for Caitlin?
Can you speak a little more about the clause? You said something about a clause.
Acceleration clauses. That was just another issue that was discussed at the law and regulation meeting, with a lot of people in the contract writing higher than the best offer, which is obviously problematic if you maybe get 6 of those. So it just seemed like an issue that people are seeing across the country.
Agent will write they'll beat their highest and best offer by X amount.
I will go up to $530,000 and I will pay $1,000 more than the highest bidder, up to $530,000.
So why is that a problem? I don't understand the problem.
It's not against the law.
If you have more than one of them, there's a cap.
Right.
Not always, all right.
I
There's
think
always a
some of
cap.
the issue was there wasn't always a cap.
There
It
should
was
be a
just
cap.
kind of
The other thing too is
multiple.
that no contingencies. It's basically boxed out the first-time home buyer because they have to have a loan. We even heard about there's some people getting inspection insurance because they're getting without an inspection. So the only contract you're going to get accepted right now is no contingencies, over full price, and whoever will go over the full price the most. No inspections, no appraisals, no contingencies.
I've seen that, and I've also seen some appraisal gap clauses that they'll make up the difference if it doesn't appraise, and then also some of the inspection gaps where they're not going to talk about anything under $5,000 or $10,000 or whatever. So, but I just don't see the problem if they're written correctly. And
The problem becomes down to realtor against realtor, and I saw some of the cases we had today that it appears that some of it's like it's happening because of that. Everybody's just kind of, they're showing 100 houses and writing 100 contracts, and then they're not getting it.
And not all escalation clauses are written the same way. And if all of these clauses are written the same way so that you can understand exactly what each one of them are saying, that's one thing, but they're not. And Tennessee, if I'm speaking correctly, Addison, Tennessee doesn't recognize the same language on all of them. So you don't know, you might write one and I write one, and then we submit those offers to Marcia and she doesn't understand what we're saying, then we're confusing the seller.
That's what occurs in most instances. The seller, in my experience, the seller will get those and like, what do they want? And I'll explain it, and then I'll say, well, I want to go with this offer that has just told me a really good number that's agreeable, and they can choose to accept that offer. And then when I respond to the agent, well, was it above price? And I might say yes if the seller has allowed me to share that. And they say, well, we had an escalation clause, and I'll say the seller chose to accept this offer as they legally can.
Last week, I had one of my agents call me and say, and he'd been showing this first-time home buyer for months, written many contracts, showed many properties, and he said, I think we're going to get this house, but the seller's agent has come back to me and said, if you'll give me a weekend at the Opryland Hotel, we'll take your offer. So he's like, is that legal? I said, we're going to have to amend your offer to do that and be specific as to how much money, because some rooms are $2,000. But so it's getting down to that. So it's causing, everybody's agitated, It's a hard time to sell real estate right now.
Hey, Steve, in your commercial business, you see those love letters a lot.
No.
I
didn't think so.
And you're happy you don't.
I'm wondering why seller agents don't maybe set set sales up like an auction, you know, and I used
There
to do
are
that.
more of those.
That have dates. Okay, I'm going to accept all the offers at 10 o'clock on such and such a date. If you're interested, bring it on.
Okay.
If not, and this
So
is
here's
it.
what happens. Every Friday, everything goes in the MLS, and it says submit your offers to the seller's agent by Sunday at 5 o'clock. That's the time limit. Then the seller's agent will present them to the seller, and then the seller will make his judgment, and I will let you know Monday morning.
What's wrong with that?
Nothing wrong with that. That's how
Yeah.
that's how it's happening.
I have told seller clients in recent months that if we were to get an escalation clause, I might advise you to go back to that person and to their highest number right off the bat, and that way it's just kind of like, well, you had to prove another offer in writing that was of greater value or whatever, and I said no. I mean, you put the number on paper. We're just countering at that number, and
The other thing is that the showings a lot of times are limited to 15 minutes. And now there's overlapping showings. So there may be 4 people showing the house at the same time, which is really bad. Also, another thing is people are taking home inspectors with them when they look at houses.
That's a smart move.
Because there's no time you need to know, before you write the contract, but because there's no due diligence time at all in any of them.
All right, Caitlin, anything else about Arello you want to report?
I can wait for this part, but I have gotten some interest on the September conference that is September 15th through the 19th. Just take the location out of it because it is a conference. But if one more commission member would like to go to that, we can vote on that today because we do have a short turnaround.
We've got Steve going at this point, right?
If Steve is still wanting to go, yes, I've got him down.
Oh,
It's September 15th through the 19th.
It's a Wednesday through Saturday or Tuesday through Saturday, I think.
Look,
No.
it's a Wednesday through a Saturday. And really, I mean, from our notes, you can see the benefit of Arello is getting to go to the sessions and hear what other states are doing. You know, often, and I'm sure Joan can speak to this as
Someone who ever been understand Arello.
who's going to check? Anybody else? DJ, you want to commit today, or John, you want to commit today to going?
I'm unable to commit today.
I have anybody? Orlando.
I think maybe if the commission just wanted to vote on 2 commissioners going and then
What's your preference?
Why don't we make a motion that 2 go, and then whoever wants to go can arrange it with Caitlin.
So moved.
And do you need us to vote on 2 people? Because I would like to vote on 3 people.
well, listen, I had a hard time getting, I had a really hard time getting even the people that, because we do send 3 staff members, which I think, I know I certainly see the benefit. So, I
I'm
think
okay.
5 is our cap right
Okay.
now.
Plus
If
me
we're
makes
lucky.
it 6.
What?
Plus me makes 6,
Yeah.
which is a great delegation from any state.
So, and our operating fund balance is only several $100,000.
I think we could argue that there would be maybe a direct use to licensees and consumers that wouldn't be this.
Clearly a direct benefit. Okay, so I'm going to, the chair has decided that we have a motion on the floor that says, in addition to 3 staff members, 2 commissioners will make the trip to Orlando. One will be Commissioner Gwynn. The second is to be determined. That's the motion. Okay, thank you, Joan. That's seconded. Discussion. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. What else, Caitlin?
That's it for me.
Questions from Caitlin in her role as executive director? If not, let's move on to the
Can I ask one thing? I'm sorry.
You may.
So
I'm
close.
sorry. So close. I
So
know.
close, yeah.
I just looked. Do I have any notes? We're seeing in Tennessee the same thing that we're seeing nationwide about the failing, people failing tests, exams. But I did, on your report, notice that 58.84% failed the national part of our test, but only 27% failed the state part. Is there anything that we could do? I don't know. Are we publicizing the schools that are passing and failing? And is there anything that we could do to help people to know these schools are not they're 100% failure rates?
I do include that in my newsletter from
Okay.
time to time. I haven't included it in every newsletter, but I could always include at the very least, a link to that pass
That
fail
would be
rate
great.
in every newsletter. I've definitely written, a little blurb on the pass fail rate and where it's located and kind of what it means.
Okay, that'd be great.
I could also find out. It is a national test, and with it being a national test and it being accredited, it means that, licensees, if they have taken the test in Tennessee, they can get credit for that test if they keep an active license in many other states. I can look and see where we fall versus other states that PSI, our testing vendor, would have access to.
When do you decide whether we re-up with PSI or again?
But I want to say it's a 4-year contract, I believe. And I think, if memory serves me right, I think we're at least 2 years into it.
Okay.
So I think probably another 2 years.
Let's move to. Hey, Pam, are you on the line?
We can see you, but we can't hear you.
Can you hear me now?
We can hear you now. Thank you.
All right, first up, you've provided us a sheet with the case numbers, 1 through 36 or so? What's
Yes.
36.
And each of these cases has a recommendation. And typically, we ask commissioners if anybody wants a case pulled. So, Caitlin, have you heard anything from anybody?
I think Marcia would like to pull 1 and 36. Otherwise,
Is
I don't.
36 the last one?
Yes.
Okay. Anybody else want to pull a case?
Motion to approve cases 1 through 36 with the exceptions of 1 and 36.
The motion offered by Mr. Diaz, seconded by Mr. Begley. If passed, we'll accept council's recommendation on all cases with the exception of case 1 and case 36. Discussion? Anybody want to pull any other case? All right, if not, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed vote no. The motion passes unanimously. Number 1, Marcia.
Okay, first of all, I want to say I'm not opposed to the recommendation of council, except that I wanted us to look at this a little bit to understand. Pam, this was listed a number on Zillow. That's where my red flag went up. And as it turns out, it went to some person who is unlicensed, and they asked for a 1% commission. So, and I'm wondering. It also says it was listed on the MLS in private remarks. So I guess my question is also to Caitlin and Anna about, number one, Is Zillow licensed in this state to sell property?
I believe Zillow does have a license.
So I would like to know who their principal broker is and where their office is located.
Well, I don't know that we can give you that in relation to this case because we do remain anonymous.
Case.
What?
Written in the case.
Well, I know, but telling you the principal broker or if
No, okay. So I guess what I'm getting at is I want to know is Zillow licensed and I mean that's my concern more than just this case. Is everything in line for this to happen again? Because it was a Zillow advertisement where it came from. Some principal broker had to be responsible for that advertising in the state of Tennessee.
the only thing I'll say, I actually had something recently because I think Zillow does have a function where you, Marsha Franks, with your firm could be advertising and like me, I'm moving from Dallas and I don't know anybody in Nashville. And so I go to their website and I say, connect me with a Franklin real estate agent. And it connects me to you independent from Zillow. And I don't know if that's what happened here. But I can't
Maybe
say
this is a fraudulent person who has no license, obviously, who went on Zillow, and because that's how else would they have the number for this person to call?
so. I literally was just looking into this week because of something else that had come up. And when I went out there, there's a whole slew. It's like people are buying ad space there, or they're paying to be a connecting option. If that
But
makes
they're
sense.
they're not a licensee.
Yes, they are.
But
They
this person
are.
was not, and they were on there.
That I cannot speak to, but you could be on there under Find Me an Agent, and I could be searching for Franklin and get connected to you with your phone number and with your firm. Because what I was,
understand that.
yeah, but
I just don't know how an unlicensed person is advertising on Zillow,
I think that would be
unless they were the owner of the property.
either a question for that.
Not like an agent. Text the owner.
And pay her $1,000.
Pam, do you have any maybe additional information that would be helpful?
The type of information I have as far as background on how this came about and how the complainant got the contact information. Without saying why I had to look into this information, I have had to do some research recently that would indicate to me that there is an organization of Zillow unrelated to this case, within the state of Tennessee, that is licensed and I believe does have a principal broker. But specifics about that and how they divide that and so forth, I would have to look into and do more research on.
Okay, it just put my antenna up, and I'm okay to move forward with council's recommendation. I just wanted to draw everybody else's antenna up too, so that we're kind of watching this.
Can an unlicensed person put a listing on MLS?
No,
Isn't that what did?
it was on MLS and Zillow.
Who had to put that on there? A licensee, right?
Somebody did.
License had
He's letting somebody use their license is what I'm afraid of. Or else you couldn't get in MLS.
That's an association problem, not
Yeah,
Trex problem.
not our problem.
Yep, I got
So
it.
I move we accept council's
Is
recommendation.
there a second? Seconded by Mr. Diaz. So the motion is to accept council's recommendation on case one, made by Ms. Frank, seconded by Mr. Diaz. Further discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 36. I think I'm gonna ask this question and see if I can get an answer to it. Is this a case related to the summary suspension that this commission put into place several months ago? It's not.
There's
No.
no, isn't it?
Just checking. I just wanted to know. All right, Marcia, what do you think?
Okay, all right. So the council's, let's see, the recommendation was to authorize a contested case hearing for revocation of this person's license. And the problem was it was bank fraud to the tune of $190,000. And when we looked at this, we revoked this license. All right. So to me, that's the hardest thing we could do to anybody.
We offered revocation.
We offered it.
Yep.
We offered it. So now they're not accepting of that, and they've come back. And I don't see anything that's new information to us, whether it's their age, they were abused. None of that information has changed. The new recommendation is based on the above consideration. Council recommends a suspension of 1 year. I want to know what changed to make them go from a suspension of 1 year when they first said a revocation, because I don't see any difference in the circumstances. It's just a repeat of the facts that we had in the first case.
For me, after her attorney got involved, it provided me some more documentation, including the sentencing memorandum, in which those in a criminal case in federal court, to the extent that you're familiar, but the process goes through. You have, a conviction, a plea, and so forth, and then it goes forward at a later date to a sentencing hearing. At that point, the government chimes in and provides a memorandum. The defendant chimes in and provides a memorandum, and then the government comes back and they address different points that the defendant made and how they're going to present that to the judge and what they're going to agree with and not agree with. And so I have some familiarity with that. And in this case, after I looked at that information and looked at some of what the government had said and how they reacted to it, I was struck very much by the fact that the government's view of the circumstances in this case was such that they didn't order any restitution, which I had confirmed through her attorney was in fact the case. I wasn't certain about before. And there was absolutely no incarceration period given a financial crime of $190,000. So coupled with that and some of the additional information about, and actually reading some statements from this lady, as well as different letters that were sent in from people in the community, from who would talk about their history with her and how she was, an outstanding pillar of the community for a number of years, led me to go ahead with and present their settlement recommendations. So that's certainly, of course, up to you all if you want to go forward with the hearing on the revocation or accept that. But that is, for my motivation was that.
So this just happened on December 22nd, 2020. The respondent pled guilty, and they pled guilty to, they opened several bank accounts, deposited counterfeit checks, and shipped large quantities of fraudulently obtained cash overseas. I don't know why the government didn't make them pay it back. That has nothing to do with this regulatory board. Our job is to protect the public. We look at the theft of money and felonies, and this just happened in 2020. So, I see no reason to change our recommendation for the revocation at this point, because nothing else has changed except that the government didn't give her a big, and it may be because of her age that they didn't put her in jail. I don't know. But I don't see letting this person loose on the state of Tennessee to be doing real estate.
One second, Jeff. To be clear, we can either accept the recommendation or commission of council, or we can not accept it, at
Right.
which point it would go to a formal hearing.
Right.
Okay, so that's what the two issues are. Jeff?
Well, I'm just curious, Pam, what triggered the revocation? Was it the fact that she was convicted, or did she not notify
Yes.
Trek?
She did notify Trek. It was the conviction regarding the financial crimes and that statutory scheme that goes into that. And two, I wanted to do a follow up to with you as well as Commissioner Frank's question. Whenever there is a settlement offer that's made by opposing party, in answer to your question of why I would bring it for commission, I'm ethically responsible for doing that. So that's additionally why I'm bringing it before you today. But yes, that is the reason for the revocation recommendation. Yes.
Other questions? So, to me, there's a case that we've handled in the recent past that's very, very similar to this, and it had to do with a widow falling prey to a scam artist.
In another country.
And she took a bunch of money out of her escrow account, not from a bank. I mean, I don't know if there's a big difference or not, but she emptied her escrow account of somebody else's money and gave it to this thief, for lack of a better term. Pam, do you recall how we handled that case, or what the end result was, or Caitlin or Anna? Do you recall the case?
I do actually was just talking to Anna about this yesterday, so she can speak more about it. But I believe in that case, Anna, did you say that she was reduced from principal broker to affiliate broker for 2 years?
Yes. So the decision made by the commission was a downgrade of her license for 2 years, and she was required to take the core course within 180 days and pay all court costs.
We had a formal hearing in that case, right?
Yes.
This is just two attorneys trying to negotiate something at this point.
Yes.
Okay.
Question.
Yes, Jeff?
Caitlin, right now the recommendation is for a suspension of 1 year. If, let's say, we were to recommend a suspension to go concurrent with the probationary period for 3 years, what would be the track of her license during that time? Would she have to maintain her license even though it's suspended in order for it to come back active at the end of the suspension?
Well, that might be a question for us and legal. Obviously, the rule says if your license is expired for over a year, then you must retest and reapply. I mean, I guess in suspended status, she could continue to renew it and keep up with her education, but she wouldn't be able. It's kind of tricky because in suspended status, I don't know how the education would work and that sort of thing. Do you have any thoughts, Anna?
I think if her license was suspended for a period of time, my concern is if it runs with her probation can end early. So if we want that to be, so the date that is given to us right now may not be the date at any given time. So if you're comfortable with it running concurrently with that probation date, I think it's possible. Like Caitlin said, after a year, I think renewal gets a bit tricky, but if they're suspended, I don't kind of see that rule specifically applying to that case. Like, I think what would happen is the licensee would need to, if this is your decision, satisfy all requirements in order to be moved back into active status. So I'm thinking paying the renewal amount, completing any additional continuing education. If you want her to have to retest and retake the national and state portion along with the courses in the beginning, I think that is also a possibility.
I'd like to make a motion.
We'll have something to discuss.
I'd like to make a motion that we not accept council's recommendation and that we keep the revocation in place.
Okay, so we have a motion on the floor that says we're going to stick with our original decision which will cause, I suspect, a formal hearing to have to occur. That's the motion on the floor.
I second.
Yes,
Because
Steve.
that gives us another opportunity to let her present her case. I don't know if it's her or not, but to present their case, if there is more evidence other than just somebody that's done something with this much. You got to put thought into counterfeiting money, counterfeiting checks.
Kiting checks.
And opening, it says you counterfeited. So I think, either she accepts the revocation or she can come before us and present her case.
Steve.
I was going to say, I obviously agree with Commissioner Franks. I don't understand why, how this is precipitated by council versus the person that we suspended the license. Meaning, it seems to me the steps are that we did what we did based on the fact that she had a felony, and if she wants to, or he wants to, no, it's a she. If she wants to come in and explain all the evidence that council mentioned, then fine, bring it on. Let us hear what you have to say, and we'll make a decision. But
So I just wanted to.
am I wrong on this?
Yes. So individuals are entitled to representation. So just like they would be in civil court or criminal court, if they have an attorney and they hire one, we operate the same way, meaning that we present you with settlement offers. So that can be waived. Some individuals they're not represented by an attorney, but because they have an attorney at that point, we're no longer permitted to speak with them. We have to speak with their counsel who represents them. And that's how that works in other court proceedings. This just happens to be the court that we're doing is administrative court. So if they have an attorney.
Oh, counsel is her counsel.
Yes. So the respondent is represented by counsel and they're speaking with either Pam or the disciplinary counsel. So that's who the other person is that Pam's been corresponding with.
Comments? Okay. The motion on the floor is to stick with the original commission decision, which was to offer revocation. That's what's on the floor. Any further discussion? All right, we'll try voice vote and see how this goes. If you're in favor of that motion, please say aye.
Aye.
If you're opposed, say no. And the motion passes on a 6 aye, 1 no vote. Was that 7? 7 aye, 1 no vote. Mr. Ferris votes no. All right, that item is handled. Pam, anything else to come before us from your perspective?
I don't have anything else.
Thank you for a short, succinct report. Very rare that we only have 2 cases pulled out.
First time ever. This was great. Great month.
Good job. Maybe a paralegal.
Thank you.
Maybe a paralegal gets some of that credit too. I don't know that for sure.
Yes, Carol always gets credit. She's a great help to us.
I can tell. That's great. Well, thank you both. Let's move on to commission discussion, and we'll start with Orello. And Madam President, do you want to start your report, and then we'll go to staff, and then we'll end up with the 2 commissioners who accompanied them.
Okay, so we had to make the decision in February whether to have the mid-year meeting or not. And back in February, you'll remember there was no vaccination. It ended up that the hotel was going to still charge us whether we came or not. So we said, even if there's 6 of us going, we're going. So we ended up, they did lower our room block to 65. And we had to go back twice asking for more rooms. We ended up with 126 people there in person, which was double what we had thought. So that was great. We had 62 that were on virtually. The plan from now on is no virtual aspects to our meeting. So the one in September, our annual meeting, will be fully in person. Let's see here. We had lots of discussion about wholesaling and what people are trying to do about wholesaling. And another subject was a broker in charge, specifically virtual supervising. That's kind of come to the top of the list too of people having problems. It was also discussed about the NAR requiring ethics complaints be sent to commissions, and there's no one happy about that, nor are they going to hear them from what I heard. They were on the lookout too for all of these no contingency lawsuits that they think are fixing to come up. At the annual meeting, we're going to have our keynote speaker is going to have to do with fair housing. And this guy is so good. He's an actor, and I can't tell you about him because I don't want to give it away. But it's one of these eye-changing things. It'll change your look. It'll make you see things you've never seen before as far as the prejudice that you might have in yourself. We've talked about timeshare. Ross, I'm going to ask him to talk about education in just a minute. We're having an investigator auditor resource seminar in October in Birmingham. Now, I know we don't even know who our investigators or auditors are, but that is something that's available to the state of Tennessee for them, and there's investigator manuals and all kinds of resources for investigators. Okay, let's see. We had a commissioner roundtable. I think we've talked about most of these things already. One of our big pushes this year is in our strategic plan from a year ago is that we want to increase our global alliances. And I know y'all are going to think this is the funniest thing that Marcia Franks is involved in this part, but we get calls all the time. It's incredible. It's very interesting. We are now in talks with Mexico, Nicaragua, El Salvador, and Honduras on helping them to start regulatory boards in their countries. And one of the things that we decided to do at this meeting is for our membership brochures to be translated into Spanish. We're also talking with Ukraine, Moldova, South Korea, Japan, Jamaica, New Zealand, and Canada. We're already good to go with those countries, but we're adding on several more countries that have indicated interest in it. So there were a few years back, they had a meeting in Dubai, and the government of Dubai paid for everyone at Arello to go to that. So I'm getting my fingers crossed that we can go back to Dubai.
I'm in on that.
Okay, so our program committee is the committee that goes over, they pick sites and speakers for all of our conferences. And so the annual meeting this year is in Orlando. Our mid-year meeting will be in April. We usually have mid-year in April, but because of COVID, we moved it to the end of June this year. And that meeting will be in Savannah, Georgia. And then the annual meeting next year, 2022, is in Nashville. And everybody is so excited about coming to Nashville. They've been wanting to come for Nashville for years, and we keep hearing it's too expensive in Nashville to go to Nashville. So isn't that interesting? So I was glad to send them the picture of the 350,000 people who came to see the fireworks in Nashville over the 4th of July. So we had a great keynote speaker, Candace Cook. She is from Texas. She's a broker, an appraiser, and an educator. And she talked to us. She teaches the Train the Trainer classes there. She's president of the Real Estate Business Institute. And in a little bit, I'll let Ross tell you the 5 things that she told me. Ross asked good questions, y'all. I was glad he asked. So we'll get to that. There's an Arello Foundation. It's separate. It's a spinoff of Arello, but this foundation was the one who gave the money for the timeshare video for us to produce. And this year we gave money to a company out of Ohio called Branches Real Estate. And it is the first nonprofit real estate full-service company. And what they do is they help people get in first homes, and they help older adults. And I just want to speak real quickly about some of the programs that I think nobody even knows we have. There's a distance education certification. I think we're going to be talking a little about that later on. the Investigator Auditor Resources, Commissioner College. Commissioner College is a 2 different day event. I've done the Commissioner College. It's basically teaches you a lot about how to be a better commissioner. One of those classes is going to be taught on the Sunday following our meeting in September. We also have a disciplinary action database where you can go in there and you can find out if there's been disciplinary action on anybody in other states. Exam accreditation, license verification. If you want to know if somebody's got a license in Kentucky, you can look it up there. And then the timeshare registry. The timeshares pays Arello for us to certify them. They have to go through this big, huge process. But it's very important. And then also, I wanted to tell you, I don't know if you're getting it or not, but there's something called Boundaries, and it's like our newsletter. And I hope that y'all will look at it because it's always full of really good stuff. And one of the things was the Federal District Court permits suit against timeshares, exits to team to proceed. So it's not just court stuff in here. We have Canada facing housing crunch similar to the United States. So there's a lot of different kinds of information in here. If you're not getting it, then let me know because we want to make sure that you do. And I just want to pass out really, really quick. I won't pass out in just a minute. So I just wanted to, we've had the best year we've ever had at Arello, and I just wanted to bring this back to you for you to see. The ones that went to the meeting, I'm sure that y'all got these things. We call it our dashboard. This shows you the first thing there's the timeshare revenue. This is where Arello is getting money from. They're getting it from the timeshare registry, the education you can see there, the certifications that we have. We have 1 full-time person and 2 part-time people that certify all our education. And they've gotten it down to, I said it's taken too long to get classes certified, so they've got it down to 15 days now, and that's at an all-time low. Our membership is increasing. Our cash reserves are great. We actually have about $4.4 million in investments. You know, I know if you've been around me very long, I like for us to spend our money on the members. And that's why, you know, I'm always saying, even here at Trek, any money that we can spend on our licensees, that's the best way I feel like we should be spending money instead of stockpiling money. So we're looking into that. Down under communications, there's several publications: the Investigator Manual, Leadership Manual, Licensure Task Force Report, Member Outreach Guide, and Member Brochure in the Annual Report. And all of that, as a member, you have a membership that entitles you to all of this stuff. It's why a lot of the different countries are coming to us and joining us, because we have this stuff ready to go for them. And then on the other page was the distance education overview. And so that tells you how many courses we're approving. And let me just tell you this, they take this very seriously. The people that are on this committee, they're very serious about it. Ross, I'm so glad, is on this committee, and he's doing a great job. So that's all I have. What, we want to go first to Ross and let you take up?
I kind of lost you when you mentioned Moldova. Where's Moldova?
I'm not even sure.
Moldova.
I said via, didn't I? Moldova.
Well, where's Moldova? Eastern Europe. Thank you, Steve.
I don't think I'm going there.
All right, so let's go to council.
You don't want to go to Ross first?
No,
do the education?
No.
Okay, go ahead.
Ross doesn't call us down or tell people we're wrong.
Ross is excited though.
Hey, sometimes that is the job. I will take that burden on my shoulders. They're broad.
It's a compliment. I'm not trying to be anything but complimentary.
So I was going to say a lot of what Caitlin said during the law and regulation meeting, but she kind of took it. But we did hear a lot of information about love letters. I had not heard about that until this meeting. One thing that Marcia mentioned briefly, we talked about the wholesaling option to buy. There was a general conversation about that, and actually, I have shared the case that we have with a few of our other jurisdictions. It's going to be submitted for the case review for Arello in the fall.
Great.
So a lot of individuals are kind of looking at that case to see how that goes. I think it is Kansas. Is it one of the states has passed a statute? Actually, Oklahoma has actually passed a statute saying that wholesaling requires a license. The timeshare committee, we talked about timeshare things, not much different from what we heard from ARDA today. They did talk about how they're working on getting resources to licensees and people concerning timeshares, because we all have, our general concerns about those. And I just learned a lot more about kind of what's going on in the market right now. Like, I think it was Marcia said before, people are having home inspectors go with them on tours, or on viewings, which I thought is really smart. They don't tell them that's a home inspector, but the person comes with them. And a lot of information was, a lot of discussion was taking place about how volatile, I guess, the market is right now, and what maybe impacts we'll see after that, as far as regulators, possibly an increase in complaints from the buyers. So it's very interesting, especially during this time period where the market is completely bonkers. So that's my report.
And I was very glad that we had Anna there that could respond and let them know about this. So I appreciate your participation.
And I enjoyed your story about your Lyft driver on the way to the hotel.
Told John.
Apparently,
It
was not a comfortable ride, as I understood it. All right. Yes.
Vanna, on this love letter thing, are agents stating in their listing either where my seller is accepting love letters or not accepting love letters? And if is a seller subjecting him or herself to the fair housing standard by possibly even accepting them, or
Right,
could
so-
a case be made against that seller down the road?
I'm glad you brought that up, because a lot of individuals that were at the commission at the conference were talking about the fair housing implications that these love letters have. I don't know if they're necessarily being incorporated into like any agency agreements or listing documents. I don't see a reason that they should be. I think that would be a decision made by the individual listing agent or buyer's agent if they want to accept those. A couple of people said they just do not present them to their clients, and I don't really kind of foresee an issue with that, but I do see the issues with the fair housing implications of these love letters. I don't know of any kind of court cases or anything moving, but it can be pretty precarious in what is provided in those letters. Also, there's really kind of there's kind of a pattern, but the pattern is really not one, and so they vary, but I would just stay away from them.
The consensus was that it's probably up to the principal brokers. In my case, I have asked my agents to tell their people that they're not allowed to present these love letters. Now, if the seller wants to go put it in somebody's mailbox, leaves my agent out of it.
The seller's receiving the love letters?
Right.
So they receive them sometimes through the mail
Yeah.
or someone
Laying on their bed.
or laying on a bed on a pillow of someone's home. But a lot of the agents that were there stated that they don't present the love letters. Like they tell their clients up front that they're not going to, but if the seller independently contacts the prospective family, like either by mail or dropping things off, that is kind of, they're gonna get.
How do you?
Yeah.
How would a seller even know if what's in the love letter is true or not? I mean, they're not going and investigating.
That was an issue. One person said that there was
You know,
a love letter presented, and then they sold it to that.
It could
and
be a
then
setup.
And
I
then
mean,
Right.
not long later, they
Yep.
flipped the house.
It could be someone of an ethnic group saying they're of another ethnic group. Like I said, like the Catholic with 12 children. Man, maybe they're totally something different, you know?
So Steve's kind of like any other love letter. How do you know it's true?
That's true.
But
If
you-
one MLS company, one MLS person or one person with an MLS said that their MLS said that they had it in their policy that they did not, they had actually put it in there that they did not accept love letters.
Right.
They
And I think
added.
the fair housing implications is probably something that we're going to be seeing fairly soon if this is a practice that persists. So
Get on the radar.
it's on the radar, and right now there's really kind of no way to verify that information is correct.
All right, thank you. Mr. White, you've been referenced several times now. Expect an exceptional report, brief but exceptional.
Chairman, I will endeavor to make it brief, but exciting and good and everything. First of all, we've got I want you to realize that our Vice President, our Vice Chairman, Marcia Franks, is doing an outstanding job for us all in Tennessee. We were recognized as probably at least an outstanding delegation from Tennessee. Ms. Franks, Commissioner Diaz, Caitlin, Anna and myself, and Joan and Commissioner Smith, and her husband. We were all there in a show of energy and understanding and force that I think was appreciated. And I've got to say, I mean, this was one of the most informational times that I've been with the committees and been there with Arello. And you got to understand too that Arello advances the cause and purpose of improving real estate education. And so that to me is the big and brightest thing it does. There's a board of directors that runs on bylaws and policies. Now, various committees are there, and you've heard Commissioner Franks talk about that. I serve on both the education committees, certification and accreditation. And now I have a seat at the table, so I have some way in which that I can help make a difference for at least bringing back information to the body here and to improve, I think, education overall in Tennessee. But some of the takeaways, I think, for me, and ideas and comments and suggestions, one thing, as I think that was alluded to earlier, was the pass-fail rates as it relates to our folks taking the exams. And here's something that I don't know is a good, I guess it's a good time to discuss as any, but it was brought out at one of the educational meetings that one suggestion was to take the pre-license course that's the 60-hour course now. And you see there's no set time after a person takes that, can be next year, that they take the real estate exam. So that period of time is open. Well, so that no set time could be changed, and perhaps that's one thing that could improve the pass-fail rate for folks to reduce the time from passing, completing the pre-license course to taking the final exam. So I thought that was an interesting point that was brought out in one of the meetings. And any comments on that? Any questions? Okay, next was pre-license versus a pre-exam course. See, now we focus on our pre-license courses. It's mainly the Dearborn Manual. That's what folks study to take the 60-hour test. Well, the focus is on pre-licensing, but perhaps we should change that focus and call it pre-exam. And the idea being that then, they're going to get the information, but they need to realize that they're studying it for the exam. And I've heard comments from folks who've taken the exam and others that, well, they don't get really what they need to learn out of the 60-hour and or 30-hour courses. So perhaps just a shift in the focus from calling it pre-license to pre-exam. I thought that was interesting. And then another point was, and Director Maxwell has already, established this, is have education roundtables in which we have all the providers in this room, everybody accounted for, that we can to have discussions just like we're having now about how to improve education here in Tennessee, and individual development workshops, I guess we could call them, and or that goes along with also instructors, because our instructors are kind of the ones that really are out there making the difference, and I think our focus needs to be on them as well. As was mentioned, I think we're going to talk about this some more, but for synchronous courses now, they just started this program end of last year. So it's a 15-day review time now, turnaround, which has gone down from 30 days, I believe. And also interesting to me was that webinars is a format that we have. Well, they're synchronous too. And the webinars are the same as synchronous courses in the way that Arello reviews those. Okay, and finally, this is quick enough, succinct enough. But finally, our keynote speaker, Candace, that I believe Candace Cook. Yeah. She mentioned 5. I asked her the question, what are the 5 things in a takeaway that we could have that would make the most difference in real estate education? And she said 1 would be, and this was put her on the spot. I mean, she was not ready for this question, but she handled it admirably. But anyway, the question was, what are the 5 things? 1, raise the bar on education. So I'm all for that. Number 2, raise the bar on the educators, and that's the instructors. Number 3, raise the bar on us, the regulators or the education folks, and recognize their challenges, but work through those things and navigate through those things as we are today. And I thought this was a good one. Give students what they need. They're trying to pass the exam. So there's a lot of things that go in the that sort of gets obscured from what the purpose is, and that's for those folks to pass the exam. Now, I thought that was a good one. And 5, to actually improve the exams themselves and help this rate passage, in which I discussed earlier. And then there was a number 6, which I just threw in there too. What about mentors? Everybody that is a professional in this room had somebody that helped them to get there. And what could we do to perhaps good practices toward that end? And that's my report.
Everybody loved Ross. Everybody
Why
loved
wouldn't
Ross.
they? I mean, what's not to love about him? Except his beard. Still not crazy about that. All right. Thank you, Ross. Joan
Thank you, Mr.
Smith,
Chairman, members of the commission.
Anything that you'd like to touch on that hasn't been covered, or you'd like to emphasize?
Well, and follow up, Candy Cook, who was the speaker, recommended a book, Thinking Fast and Slow. She said was a great book to read. I hadn't done that yet. Thinking Fast and Slow. And I think she said it was a Candyman or Candace Man or something like that was the author. Do you remember?
I've got it written down at home. I don't have it with me here.
And then repeating some of the topics that we talked about was of course, the home inspector going on the showings now was real important. Escalation clause was a big topic. Again, that's such a vague discussion and a way to write those. And the other thing was the importance of understanding fair housing when you're talking about these love letters and how that can really be an issue as far as fair housing. And then we talked about elder abuse and how to be on the lookout for that, especially as realtors, as we're out and about, to be aware of elder abuse and how to report that. And two things, and I'm not going to steal his thunder because he's got a couple things to talk about, but I'm going to do one of them and let you take the other one.
Okay, thank you.
I'll take them both.
No. One of them was Commissioner College. And I don't know how many of you have done that. I know you have. You probably have.
Nope.
But as Marcia just talked about, it's a two-day class or two-day course, but they only do it in the fall. But you can, and I think this fall in September it's part 2.
And actually,
And you
I
can
forgot
do
to
it.
say
You can do it
that it's now online.
online.
You can take it anytime.
And you can, that was my point. You can do it online. So if you're not going in the fall to take it, you can do it online. And one lady was there and she had just finished it. And she was a first year commissioner. And I said, and she finished it in 8 days. So I made a point to go over and talk to her. And I thought, my goodness, how'd you do this in work? And so I said, how long did you do? Did you just do it all day for 8 days? And she said she worked on it a few days each day. So it's something that's doable. So it looks like something we may want to work on. But it would be through Arello, and it's called Commissioners College.
Does it go towards CE?
No,
No, it's a freebie.
but maybe we could think about that.
I think that would be something good.
I mean, if this meeting today goes towards CE, why wouldn't Commissioner College go for it? We have
But
that.
this doesn't go towards CE for me.
I know it doesn't, but we have that discretion. And we can,
That's true.
we're a commission. We can do what we want to, right, Joe?
So anyway, and then I'm going to say ditto for everybody else, and then
Jeff.
Jeff.
I think the one that you left for me was the concept of a commission retreat, which I thought was pretty interesting, allowing us to get together as a commission outside of our normal duties to kind of have this kind of interchange of information and education, or maybe a presentation from another organization like ARDA or stuff like that. I think that might be something that we investigate to see how we would do that.
I don't think they have the sunshine law if they're doing that.
Yeah. So,
Sounds like she just put a.
probably, but I just thought it was interesting.
I like the idea,
Yeah.
but
We couldn't
I
discuss
think that
commission
state
business.
must not have the sunshine law like Tennessee
You
does.
can invite the press. Invite the press.
Anna Red.
Yeah.
Notice the public and allow public to stream your retreat. That could be a consideration. But if you're going to be discussing board business with more than 2 people, it's going to be considered a meeting.
So board business is considered, is there a scope of that? Is it just anything the board discusses, or is it handling cases? Is that considered?
It's not about being a better commissioner, though. We can discuss being a better commissioner anywhere. It would be discussing cases or anything that might come before us.
Anything that might come before you, anything that might directly tie into the commission, like that
So
gives
it's
me
hard.
anxiety.
So it's hard. It's hard to delineate. So it would just be better to comply with sunshine.
It is, but if that is something that the commission wants to do, we can look into it. But we do have to keep those considerations in play.
What I thought about is that on one of the months that we're not using the second day, we would do it because that second day is already noticed.
If that's something that we can think about, we can talk about
Yeah,
it.
I think if it's something you'd be like open to being publicly available.
Yeah.
Get at least 3 commissioners in San Antonio together with staff.
But Anna's there.
Well, no, but that's not the point. If you guys were making decisions, anything that might be related to the business of this commission, you have
don't
to
do that.
I know you don't do that, and you don't have to do that in a retreat either. You can talk about concepts. It's not a bad idea, Jeff. I know members of the staff got a call. That's not a good idea because we might violate something.
And kind of a laugh line that got everybody kind of laughed at the same time was somebody mentioned something called appraisal insurance. And everybody went, appraisal insurance? What the hell? What is that? And, she says, nobody's heard of that? And everybody unanimously, no. It was like one big no. Like if your deal doesn't appraise, then the insurance will kick in the difference. And I was like, I thought insurance people were in the business of not paying out.
Yeah.
So, I just thought it was pretty interesting. But everybody else covered everything.
But I would like to say a thank you to Caitlin and to Commerce and Insurance for letting us go and supporting. I have felt very supportive this year as president, and I really appreciate them letting us go because some states were not allowed to go. That's why we had some that were virtual because their states were not open to travel even. So I am thankful.
And I'll finish this up by thanking all of you for taking your time to do it. I mean, it's not an easy thing just to say, okay, I'm going to take 3 or 4 days out of my life and go down and try to make this state better. And so from staff's point of view and from commissioner's point of view, thanks for doing it. It's not, not easy.
We had some receptions and parties at night, but it's a working group. It's not a vacation to go play golf or, everybody went to meetings the whole time. So.
All right, let's move on to the next item, which is the 2022 calendar. Each of you received an email with suggested dates. It's important for us to get this calendar adopted as quickly as possible because it has everything to do with reserving this room before some other commission gets it. So I hope you've had a chance to take a look at it.
One date to add that we were able to get from the association is their February conference. I think the TNX, I believe is what it's called, is February 8th through the 10th. So currently that does seem to line up with the dates that we have established, which seem to work well. Obviously this year we were virtual, but the last time we did it in person, that way the commissioners don't have to travel twice.
And so we changed it again this year to Tuesday, thinking that's when that they would want us to be there on the 9th.
You look
on that
at
Tuesday.
that. I actually think
both Joan and I both have been in contact with TR in the last 24 hours, and so I'm surely they could work into the program. What's convenient for us to be there time.
They need us more than we need them.
So that's a typo. I kept in line with Wednesday, Thursday. So that date should say Wednesday, February 9th.
Okay.
And Thursday, February 10th. So now we could do Tuesday, Wednesday, and do the 8th and the 9th.
I think we should do that.
Do Tuesday, Wednesday?
I mean, I think each time it seems like it's a Tuesday afternoon. And I don't want to stay over an extra night
because they come in on Sunday. So, and Monday starts the meetings, and then Tuesday is when they usually want us.
So does anybody have heartburn with the February meeting be Tuesday, 8th?
How about the date?
No, that's... I say if we tentatively adopt this calendar and next month you come back and say, hey, here's something we didn't take into account, we can change it again. But just to help Caitlin get this room on the books. I support that.
And I will tell you, in January, I won't be able to make it because that's the week of our Rello Leadership Conference. But I'm only one person, so y'all fine without me, unless it's a problem with somebody else.
With the change for February, Tuesday, Wednesday,
the 8th and 9th.
The dates are wrong, yeah. So it would be Tuesday, February 8th, and then Wednesday, February 9th.
All right, let's see. Let's get a motion just so we can get this voted on and off the table. Is there a motion to accept the calendar as amended for 2022?
Well, that's not the only date I wanted to ask about.
Oh, we could have a motion.
Marcia, did you get the Arillo dates?
Yes. There is the Rello mid-year is April 11th through 15th, so that's the week that we have down for April, and then September 12th through the 16th is the Rello annual in Nashville. And then one other thing, if anybody else, I don't know anybody else go, I go to NAR. That's November 11th through the 14th. But if I'm the only one it affects, it doesn't matter. Uh, 12 through 16.
Caitlin, anything you'd like to take these? I can work on this.
Yeah, I can do. Obviously, we don't want, it's better to not have like only 2 weeks in between meetings
Right.
or, a quick turnaround. So I can go back and look at April and September and just try to make sure that they're distanced from March and May and August and October.
Because I'm hoping when we have it in Nashville, I would really like for everyone, since it's in Nashville and the first time here, that everyone would be able to go to that. I mean,
Next year, September's 12th through the 16th.
Right. Maybe not everybody can, but
So
there's no travel involved.
So if you were to send out a new calendar, I don't know that we have to have an official vote on it. If everybody received a revised calendar from Caitlin, could you reply back to her and say it
Yeah.
looks good to me? And
Yeah.
if you get 8 out of 9 saying it looks good, let's just go ahead and
Just do the
schedule
best
it.
you can. That's
Yeah.
fine.
Okay. So I'll look at those 2 months, and then I kept May and October on the Thursday, Friday. I know we might have changed that some around last year. Does anybody offhand have a preference?
I like when we travel going on Thursday and Fridays in case you want to stay over.
This year we changed it because Joe wanted to change, and then he didn't manage to show up.
Yeah. So anything Joe says, we're taking.
July dates.
And the October date in East Tennessee, that's we always like to go to East Tennessee whether we're having a direct meeting or not, and that's fall break for my school.
Okay, let's just kind of
Name my grandsons.
let you work on it, send it out. Let's get, and like I said, we can change it if something shows up like a snowstorm. or
And one
something
other
like that.
thing, CMA Fest is June 9th through 12th.
Okay, so
That works.
That's when we're here.
No, we're leaving on the 9th.
In June? Okay. Might be hard to get a hotel is my only thing.
yeah, I guess if
We're
I
gonna
think
hotel
after
now.
we finalize these other dates, we can go to the hotel, get them confirmed, and if we have any issue, then we can come back to June.
Let's move on. October meeting, we know when it's going to be. We don't know where it's going to be. Is that right?
That is right, and we have an invitation that is the only invitation we've received, and I think depending on how you look at it, it is our time to go back to the Tri-Cities, and they are welcoming us with Open Arms.
Where did we go last?
So we were supposed to go to Chattanooga last year, and that obviously didn't happen. And then prior to that, we were in Farragut.
And before that, Tri-Cities.
Yes.
So we've not been to Chattanooga.
We have not.
Nor have they invited us.
Nor have
but-
they invited us. Tell
but-
your brother.
My brother. You think I talk poorly about other people? You ought to wait and talk.
I think it's important if somebody's inviting us that's should be a huge consideration.
Yes, and I think both Joe and Stacy would be welcome at a local meeting.
I'm going to vote however Joe votes. That's how I'm going with this.
They know where to eat.
He's going to vote to put Stacy in charge of the whole thing.
Since she's not here, let's go ahead and vote.
All right, so we can do this without objection. Is everybody okay with meeting in the Tri-Cities? What does that mean? Bristol or Kingsport or Johnson City? Do we know the location?
All of the above.
We don't know where yet.
Don't forget Gray.
Oh, Gray, yeah.
Gray what?
That's the name
Tennessee.
of the town. Yeah. Yep.
Went to Gray.
I believe we stayed in Gray.
I thought wherever it was, we're glad to go back.
Yeah.
So let's just, any objection to confirming Upper East Tennessee is the October meeting? All right, that's handled. Now this TUR request.
And there's one more additional request on your iPad that came in after from the Memphis Area Association.
Is the TR request on this?
It should be one of the very last documents.
8B?
Eight A is ours.
Yeah, there it is.
Okay, what do they want?
So I think, without speaking on their behalf, the request is a reconsideration of synchronous courses, and it's also to let the commission know the cost associated with complying with the new certification. And I think, what we're hearing from providers and across the state is, I think a lot of providers have seen the benefit of offering synchronous. And when I say synchronous, I mean classroom in real time, but offered via platforms such as Zoom, WebEx, Teams, you name it. Whereas many providers were doing classroom courses, which have to be approved by the commission, but there aren't these additional fees. And so I did verify that Memphis and the Tennessee Association, those are projected costs, what it would cost to get approval, because there's the cost for the certification, but then there is also an instructor cost. So I think both these letters are requesting kind of a discussion on synchronous courses and the certification. That isn't a new requirement. This has always been in our law. It's just new that I think many providers are wishing to continue the usage that we were able to allow through the executive order the last year until starting in May is when we started requiring the certification for the synchronous course. So if legal wants to speak to the law, I would just say that right now we don't really define the difference between asynchronous and synchronous. Previously, what we have seen is asynchronous, which is anytime. You can take it at midnight, you can take it at 7 a.m., has required that certification, and those are the courses that we have seen it for. And whereas these are just separated by distance, not separated by time, they're in real time.
So the request in this letter from Tennessee Realtors wants us to discuss it. My initial thought is I'd like to ask the Tennessee Realtors to give us some suggestions. Can we,
From
I mean, if they don't like this method of delivery, then what do they think is better?
So we have discussed this at the department, and as it stands now, we feel like we would need a rule change in order to differentiate between asynchronous and synchronous, and requiring the certification for asynchronous and not requiring it for synchronous. We also, I don't want to say we would invite, but I think this could also be done by a change in legislation.
So you're talking about that internally inside the department. If Angela Shields has this great notion that this isn't a good idea, I'd love for her to give me a notion of what is a good idea. And maybe it's changing the legislation, and if that's the case, then they've got the wherewithal to work on that.
I think at this time, just since the commission has kind of been involved with the regulation of this over the last year, that's, I think, just making the commission aware of the cost of doing business now associated with it.
So
go ahead.
So the real estate associations came to us and asked for an exception so they could do synchronous coursework. And now they're coming to us and saying the requirement of certification is a burden of expense. Is that how I'm understanding the evolution here?
I think we worked, as the commission worked within the governor's executive order. Obviously none of us prepared for March of last year and how that would change business and how it would change people's daily life. So we did allow it through the executive order, not just for the association, but for any provider offering courses at that time, to work within the governor's executive order and to, allow providers to continue to do business, but also allow licensees to continue to take education and not limit that to only internet-based courses.
Said the requirement of an Arello certification.
Sorry, what?
In statute.
The requirement of an Arello certification is in the statute. It's not there.
It's not. It's in the statute. I would say, obviously, the way we do business and the way I had not used WebEx until maybe I had used it, but I hadn't used it to the volume that I use it now. So I think over the last year, everybody has seen different benefits to using technology that they now want to continue to use, that we weren't really getting many webinar certifications or many synchronous class courses coming to the commission before March of 2019. March of 2020.
So essentially what was happening is there was synchronous courses available, but nobody was really doing it prior to COVID. So the 6,000 is the cost. Okay. I'm looking at the MAR letter.
Yeah.
So the cost for MAR was always there, but they were just really not using those courses. So then COVID happened and there were synchronous courses and that cost was still there, the Arello cost, but we said, you don't have to pay it. Is that what happened? And now that COVID is over, people like the synchronous courses, so they still want to take it. And what we're saying is no problem, but you got to be certified by Arello, and MAR is saying it's costing us $92.10.
Yeah, it would cost. Yeah,
it would cost. So, is that kind of the series of events that got us to the MAR letter?
That is essentially the series of events. I just would say we didn't have a large volume of. We did have some webinars.
Very few.
Very few prior to. And I'm calling them both, but for the purpose of this, primarily what we were seeing prior to March of 2020 was the webinar, which is essentially the same. It's in real time. It's
so if you give a
live,
course,
no interaction.
With interaction, but with a separation of distance.
So if you have a course, if MAR does a course that's not synchronous for contracts, I'm making this up, it costs them what? And now if they do that same course, which requires an Arello certification, it costs them $92.10 or whatever the number is, correct? Is that so?
That is their, I think
or
they.
is that a delta? Is that in other words, that's an additional cost?
So right now, to get a course approved, there's the fee that track, which is pretty low. I think we even reduced it within the last couple of years. Ross could speak to the exact fee, but under $100.
Yeah, it's a nominal fee to get a class. We have 4 formats. One classroom for a course up to 9 hours is $10. Used to be $25. Go up to the 30-hour course. Used to be $50. It's now $25. You go up to the 60-hour course. We talked about the pre-license course. That's now $50. Used to be $100. So, but that's your nominal fees that Trek charges for us to review these applications. If they go to a classroom-only course, if they go to an internet course or a webinar course, then they have to get the Arello certification. And heretofore, I believe it was $500 something per course for the asynchronous internet course. Now, Arello came out with the synchronous, which they've put that now at $460 per. But there's some advantages if you have multiple courses and or when you renew with them.
Oh, using I just did the math. What they're saying is $92.10 for 28 classes. So that's $329 a class. Does that sound right?
It's on a rolling.
That's 6 times what or whatever the number. I mean,
I couldn't understand I didn't understand how they figured this. We'd have to discuss that with them. I think they're thinking, as Caitlin said, I think it was.
So it's a rolling fee. There's a one price for the first, and then a different price for the second, and then the renewal is another price. It's a little bit lower.
Recertification.
Yeah.
Okay. The 6,075 is.
And then they're also including an instructor cost. So
yeah.
So I think all of those things went into how they got to their number. But we, obviously we wouldn't know exactly how many instructors they have teaching their 28 courses. So, I think those are the numbers that went into their calculation. And so I think in general, it was just to allow the commission to see the cost of doing business. And I think a lot of people want to start offering, and I gather this at Arello too, hybrids where, we are all here in person, but then we have other people that still want to attend, and they want to attend virtually. And so being able to offer licensees both.
Ross.
So I understand, MAR and TR, they made a business decision to offer asynchronous and synchronous courses to their licensees and to their members. That's right.
There's a need for necessity.
In response to COVID, so that they continue a revenue stream of their education classes.
Yes.
So now the COVID emergency has lapsed in Tennessee, and now they're having to face these certification costs for the business decision that they made. So to me, it just seems like they need to make a business decision about whether or not they want to absorb these costs.
I think there's more to it than that.
Or charge more for their courses.
Yeah, and it's going to trickle down, obviously, to the individual licensee holders. And
yeah.
I'm keenly sensitive aware about that in Greater Nashville, and I don't want my fees to go up anymore. I may choose then to spend more time in person in class rather than synchronous. But Ross, I got a question. Is there any duplication here from approving any of these instructors or courses? And
duplication,
right? Like if you, because help me understand.
Yeah.
I sit back naively trusting, knowing, and fully confident how you approve these instructors, and feel good. I feel good about all that. Could it might be something?
You can be approved with Trek and not be approved with Arello. So the Arello certification is a higher standard, probably.
Okay.
That's the
Right.
difference.
Okay.
Right. And once you're in a.
So you
an
can be
inst-
one or the other. You don't have to be approved unless you're doing a asynchronous class, right?
Considered a distance course, so at this point, and so they then have to get the Arello certification.
And that's by statute. And when did we vote? Was that recently, in recent months?
So the fee didn't occur during COVID?
We didn't require Arello certification.
We had latitude. So
Okay.
there's been a lady inching her way up to the front here who's dying to speak. Addison, who's with Farrer and Bates, which is the lobbying arm of the Tennessee Realtors, has got input. Welcome.
And thank you all for discussing this matter today. So just kind of wanted to speak more to the letter and kind of my understanding of the issue. If you look back in the spring report that Trek puts out in the education update, it says on there that on January 1st, 2021, Arello began their synchronous course approval. So it has been in statute for a while, but during COVID and pre-COVID even, Tennessee Realtors and other local associations were offering synchronous course approvals at no additional cost through the Arello certification. And the organization certainly understands the statutory requirement and that the commission's hands are kind of tied at this point now that it's offered. The only latitude within the statute is that it could be Arello certification or other certifying body. And so I don't know if there is another certifying body, if that is cheaper. But we wrote the letter to just kind of get the conversation started about we think it's convenient for licensees to offer synchronous courses. And we're here to benefit licensees. And so we don't want that to be a cost prohibitive function for the local associations, particularly given that they're nonprofit associations. So, to start the discussion as to what may be a more palatable law change, if one needs to occur, whether that's, as Caitlin mentioned, differentiating between asynchronous and synchronous, or exempting nonprofits from that certification requirement. And also, I will say Angela Shields is on the WebEx call, and so she can kind of speak more to the details about from the organization standpoint.
I appreciate your being here and your remarks. And it's one thing for Greater Nashville to have somewhere over 10,000, 16, 15, whatever the number is. Memphis to have a high number. But I'm also keeping in mind these smaller realtor associations. And I think of our visit in May in Jackson. I don't remember the gentleman's name, but the president of that association, and talking about there's just not, the coffers aren't there, and furthermore, not to put, I was thinking about the initiative mentioned by Assistant Commissioner today, and I think Executive Director, about the focus on the distressed counties, and there's just not, I don't know, I just want to be sensitive about this cost. The market always drives things, and but if we can, as a commission, affect the statute in any way, I'm open to hearing about that to, keep more money in the people's pockets, but rather than to a national organization.
And I think also this doesn't just affect TR's members or Mars members, because there's a lot of classes, probably the majority of classes, are not being taught through those two entities. So there's also, my friend at the Williamson County Association that wants to teach a class. And I've gotten calls from members there. And it is very expensive. I don't want to speak to it as president of Arello. I can tell you that they're not looking at changing the fees. So if there's anything that we could do on the state level, then I would be for that, because I think we want to protect the consumers, number one. So we need to make sure that they're provided good education. And I think it's important that the educators have either certifications or some sort of qualifications where we know, because we're seeing so many classes where people they're failing less than 50. You know, if you look at the report, there's lots of people that are not meeting the standard of it having even 50% of their people pass the classes. So it's kind of between a rock and a hard place. And I agree with John that maybe that TR or MAR or anyone might make some suggestions to us as to what they think might be a good solution.
I'm not suggesting that the two letters we're trying to put the solution to this issue on the commission, but it's from a trade association with 30,000 plus members who must have more resources than we do to come up with a solution that might work, including the legislative solution. And I would love for Tennessee Realtors or Memphis Area Association of Realtors to say, hey, what do you think about this idea? And give us something to discuss rather than just want to start the discussion. I'd like you to go back to your education committee, go back to governmental affairs, and say, let's go to the legislature with this piece of legislation. We'd like to know what you think about it before we go. But I don't just sending letters to us saying, why don't you guys start talking about it, can boil down to a waste of time at some point, unless we have something to actually discuss, which is what I hope you guys can do.
But we're not closing the door. The door is open to their suggestions.
It's just I don't have the brain power. You know, I have 8 commissioners, 14 staff people, maybe on a good day. You guys got 30,000 people, executive officers all across the state, education coordinators. We got one. Come back to us and say, hey, here's a great idea. What do you think about it? We're likely to think it's a great idea. But I don't want to be the person in charge of coming up with that great idea. I want to be the person in charge who says, well, yeah, that is a good idea. I don't have it up here to do it.
Mr. Chairman, on that note, I think that there are 2 options possible at this time that we kind of thought about. And so if you could indicate it, if the commission would like to discuss those now, and that would be saying, okay, maybe we require a RELA certification for asynchronous courses, but not synchronous courses. Given that the synchronous is kind of in real-time operation, and we understand the distinction there, if that would be a palatable compromise, or again, if legislation, I mean, and this is coming from purely an association standpoint, exempting nonprofits from that, since the associations are nonprofits, but the for-profit business schools still having to get certification.
So I like the ideas, but I'd like for them to run through council, let them tell us whether that's even something we can consider. Does the current statute allow those suggestions? I'm not smart enough to know that either. I rely on council to say it's a good idea or a bad idea. My guess is this commission will be receptive to some way to cut costs, but we got to be able to do it. And I don't know legally what we can and can't do at this point. Maybe we can have a rule change, but that's going to take a year or close to it, right? I mean, it takes forever to get the dang thing done.
I'm not saying anything new here, but I know from hearing with colleagues at Greater Nashville that a synchronous class, manning that, policing that, setting that up is far more taxing than an asynchronous. Is that right? So just a little comment for the record. And then to charge more for the course is just begins to be more taxing. But
I think it'd also be good.
Okay, go right ahead.
Addison, last month, one of your colleagues, Ms. Matthews, was here to talk about the ability to advertise charitable donations out of commissions, and commissioners offer their informal opinion, so it's not worth a lot. But one of the additional comments I wanted to make is that if they begin advertising the fact that they give a percentage of their commissions to charities, I think it's important that they be able to prove that they actually meet that burden in their record keeping, lest they be open themselves up to a misrepresentation charge. So I think that's the only other one comment that I thought might be a pitfall for that kind of a policy or practice. So I just wanted to say
Thank you for that comment. And I think a lot of that conversation, when I went back and listened, we're getting completely off topic now. And I will say that she was here not on behalf of Tennessee Realtors. So she had a separate client on that, but was about kind of giving portions of your commissions to non-licensee and how that works out. So, but I know she's appreciative of you considering that.
Other comments, Steve?
I don't know if it's on Arello's website or not, but it would be good to look at what do you get when you get a certification from Arello. What does that really mean? Meaning, if the $328 is the right number, okay, you're paying them that money for a certification. What are they doing different than Trek is doing, that you're doing, that other people are doing at a less cost? So
I think, and you sort of alluded to this, DJ, but I think part of the argument too is on an asynchronous, you can create that course, it can get approved, and then it can go and be approved in every state. And that certification really holds a lot of weight when you're getting it approved in different states. And I think part of the problem with the synchronous is that it is in real time. So it is offered at 10 p.m. or sorry, not 10 p.m. Nobody's going to go 10 a.m. on Thursday, July 8th. So it's kind of like a one time, and you, once you have that approval, you can offer it more. But it's different than an asynchronous where it gets approved once and it's approved for the renewal cycle, and then it can go to any other state and also be approved. Does that make sense?
So it's only approved for that one day at that one time?
No, it's not. But you have to offer it in real time. So I think DJ mentioned the work that goes into offering it that one time is different than maybe an asynchronous course that you do the work on the front end. It gets created and approved, and then can be taken anytime. Synchronous cannot be taken anytime. It has to be taken in real time.
So would it make more sense to give the asynchronous for that to cost more as opposed to the synchronous?
Well, I don't think that's really up to us because it is an Arello certification.
Okay.
So they're setting the cost.
Okay.
I just bring that up to differentiate the two.
How long has that Arello certification been on the books? It was before I got here.
In the law?
Yeah.
2009.
Okay. Any other comments? Addison, let me finish with this. So I really want you to know that we appreciate how much of an advocate you and your firm are for the professional realtors in the state. And I especially want you to know how much I appreciate the relationship I have with Russ Farrer, who I and others on this panel can feel free to call anytime and say what's on our mind. And he also is very good about calling us and telling us what's on his mind. And I like that relationship. Yeah. In years past, there was a real adversarial relationship between Tennessee Association of Realtors and Tennessee Real Estate Commission. But because of Russ's efforts and having people like yourself who show up and do what you're supposed to do in a professional way, we've got a great relationship between us. And so if I sound like I'm yelling at you, I don't mean to be yelling at you. I'd express the frustration of how limited this brain is right here, and I'm counting on somebody else to pick up the slack. But tell Russ I said hi, tell Russ the commission said hi, and keep up the good work. We appreciate you. All right, what other business to come before the commission today? Wait just a minute. Wait. So
somebody's hungry.
We got to travel. I know. Thank you, Carol. Thank you, Caitlin. Now this is who she described as sweet Caitlin. Is that what was that last year?
I wouldn't go there.
Well, too. I'm telling you, she found something that people have been looking for years, and might have just been good luck. But let's put that on your resume. Thank you, Anna. Thank you, Ross. Commissioners, anything? Steve, anything you'd like to say? DJ, John, Ms. President.
I got one last thing to say.
I wasn't. How
okay, I just have to tell you because it's kind of an announcement to my family of realtors here, of licensees, I should say. Okay, so at Arello, I'm in a meeting. The executive director comes and says, "Marcia, come here. So I'm going, he said, we got to have a double signature with the hotel. And I'm like, a double signature for what? And he said, just come on. And he was like leading me down this hall. And as a realtor, I'm going, I'm not signing anything. I'm not signing the bill. I have to read it. I can't sign anything. But he's going to come. And he opens this door, and there stood my husband, which he's never traveled with me to Arello. I was so excited. Then out runs my little grandson. Yeah. I couldn't believe that my daughter let him bring my grandson with him to San Antonio. Then out walks my daughter, and they said, there's somebody behind you. I look back, it's my other daughter and her husband. The whole family came, and they came to announce to me that I'm going to be a grandmother again. Tanya's having a little baby, so
as opposed to a big baby.
Well, she'll probably have a little one.
Okay. Well, congratulations.
Thank
That is
you.
great news. You should have started the
Thank
show
you.
off with that today instead of using it. Save it to the end.
Mhm.
Joe, anything? Jeff? Joan? All right, guys, there's a motion to adjourn. Thank you all for what you do to make us look as good as possible, which sometimes is problematic. We are adjourned.
Good job.
Good job. Good.
Thanks for using WebEx. Visit our website,